All right. Court of Appeal and for the sixth to the state of Florida is now in session. And will keep White, Judge presiding. All persons having business before the court shall all near give attention and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Thank you, Marshall Crawford. Good morning and welcome to this oral argument session of the Sixth District Court of Appeal. I'm Judge Keith White and have the honor of serving as the presiding judge at our oral arguments here today. Serving with me today are Judge Joshua Mize on my right and Judge Rachel Kamoutsas on my left. Just a reminder that this is being both video and audio recorded. So please make sure that your phones and other electronics devices are on silent. We have several cases on the docket today. First case that we have is Gloria Walton v. Westgate Lakes. Both counsel ready to proceed? All right, counsel for the appellant. Normally, we set 5 minutes as sort of the default rebuttal time. Is that sufficient, counsel?
Yes, Judge.
All right. Are you ready?
I am.
All right, please proceed.
Good morning. May it please the court. My name is Chad Barr, and I have the privilege of representing the appellant in this case, Gloria Walton. We are here today because the trial court entered summary judgment in the appellee's favor on the issue of notice by application of the wrong summary judgment standard and when disputed issues of fact were present. The first issue is the summary judgment standard applied by the trial court. According to the trial court, in order for Ms. Walton to be entitled to rely on the inference that she slipped on rainwater tracked into the store, she needed to prove that inference to the exclusion of all other inferences. And I think it's important that we go to the trial court's wording. The trial court said, this is not an instance where the main inference underlying Ms. Walton's case could be established to the exclusion of all other inferences. So in essence, the trial court did not resolve all inferences.
Wasn't the trial court talking about when you're stacking inferences? So when you're typically in summary judgment, you can't stack inferences. Obviously, if you're just one level of inference, then the court has to take it all in the non-movement's favor, right? But you can't stack inferences in the non-movement's favor, right? So if ruling for the non-movement would require you to stack inferences, you can only do that if the first level of inference is in fact all other inferences are excluded, right?
Well, the issue of stacking of inferences, the court can stack inferences if you look at a set of facts and they lead to one conclusion. And that's what we're saying in this case is that.
So what you just said is if you look at a set of facts and they lead to only one conclusion,
Right.
That's excluding all other inferences. That's what I mean. When you stack inferences, that first level of your stack, you do have to exclude all other inferences.
I don't think the case law supports that strong of a position. I think you can look at what we're saying in this case is that it's very simple, and I don't think there's any stacking of inferences in the first place. But what we're saying,
when you talk about the trial court standard, and we can talk about whether there was stacking of inferences, but with the way the trial court articulated the standard, that's what I took the trial judgment meaning is. She was viewing it as a stacking of inferences, and we can say she's wrong about that. But I don't think she inaccurately described the standard that applies when you stack inferences. Does that make sense?
I do understand what you're saying. But taking the court at its word, which is she did address the stacking of inferences, but she also said that we had to prove the inference, which is that the plaintiff slipped on rainwater to the exclusion of all other inferences. And in this case, that's the only inference that we're relying on. There's no other stacking of inferences. So in this case, we have the cumulative summary judgment evidence was that rainwater was regularly an issue inside the store. It was raining. 70 customers came in the store through that one path. That's the facts leading to the inference that there was rainwater on the floor.
So you had an assumption in there, and the assumption is that you described the condition as rainwater being in the store. And I'm not sure that's the right condition for purposes of 768-0755. Seems like the right condition would be rainwater in the spot right? And it seems like that's where you and your, opposing counsel disagree on the nature of the deposition testimony. It does seem to me like the idea that rainwater just can happen in a store. If that was the defined condition, then the store would always be on notice of rainwater anywhere in the store at any time. That would just kind of eliminate the whole requirement for constructive notice. Just the idea that water can get inside would mean they are always on constructive notice of water anywhere in the store. So since that would defeat the whole purpose of the statute, it seems like the relevant condition has to be there was water in this spot.
Well, I think that there's testimony that there was water in the spot. That was Miss Walton's testimony, is that there was a rather large puddle of water.
Wait, no, but hold on, you're twisting things, or not twisting, but you're responding, I'm not.
I understand.
Espousing intent,
I
I just, you're
understand.
getting to a different area. She testified she slipped on water. That doesn't go to whether this condition regularly occurred, right? Because you've got to establish one of two things for the constructive notice statute. You've either got to establish that this condition existed for a sufficient length of time, right? That it was the business should have known that the water was there, or that the condition occurred with regularity. Her testimony says, yes, I slipped on water. That has nothing to do with the constructive notice under A or B. So we were talking about B because you in your answer, described the condition that occurred regularly of water being in the store. And what I'm saying is, it seems to me like that defines the condition much more broadly than the statute would allow, because if you define the condition that we're examining the regularity of as water in the store, then literally no matter where water is in the store at any time, there would always be constructive notice. You see what I'm saying?
I'm going to try to answer your question the best that I can. The statute requires us to demonstrate in order to prevail, to demonstrate constructive notice. Our position is that we demonstrated constructive notice, or at least demonstrated a genuine issue with respect to that by virtue of the fact that, and this is coming straight from the case law, that rainwater was regularly tracked into the store when it rained. And this wasn't a normal rainstorm, this was a hurricane. So we have that, which goes to the issue of constructive notice.
Okay, so what you did, I articulated a problem with the standard you gave, and you re-articulated the standard. And so what I need you to do is address the problem that I identified, okay? I need you to go a level deeper than you're going.
I don't understand, and
So, all right,
forgive me.
So there's two ways to define the condition that you're looking at the regularity of. One is water in this spot, okay? The other is, the broader way to look at it, water in the store generally. Okay, and that's what you're asking me to do. You're saying that there's testimony that water gets in the store, and that's the regular condition. That's
No,
how I view what you're
No,
saying.
the condition is the rainwater being tracked into the store. That's the condition.
Exactly, the store generally, as opposed to rainwater being in this particular spot that she fell or slipped, she didn't fall. But you see what I'm saying? That there's two different conditions. One can be the rainwater being in this spot. One can be the rainwater being somewhere in the store. And you've said a couple of times that the condition was rainwater gets in the store, right?
Right.
Okay. If rainwater being regularly getting into the store generally gives you constructive notice of it being in a particular spot, right? Then that would mean that no matter where rainwater is in the store, at any place in the store, you always have constructive notice of it because rainwater can get in stores.
So we go to the testimony of Mr. Wampler, if I'm saying his name correctly. And he testified that rainwater is regularly tracked into the store in that area. He testified that.
Counsel, let me stop you there as a follow-up to what Judge Mize said. I believe, looking at the summary judgment evidence in the light most favorable to your client, that it was established that rainwater in what I'll call the foyer area did occur with regularity. By the foyer area, I mean the area between the two sets of glass doors where there was the warning marker and there was the map. Are you with me?
Yes.
I understand Judge Mize's question that let's assume that we agree it was established with regularity that rainwater got tracked into that foyer area. His question is, does that mean as a matter of law that it is occurs with regularity through the next set of double doors going not to the outside, but into what I'll call the store? Is that your position?
Well, yeah, I mean, our position is that area. And so there,
What area?
the area, when we're talking within 7 feet of the door, we're talking 7 feet of the front door, where you have customers walking in, and the video is very telling it. I assume that you folks have seen it, but you have 70 customers walking in and out of there, shaking their umbrellas, shaking their ponchos. And it's not even necessarily
In the foyer.
also inside the store as well.
But where did the test? I just tell you, we read the deposition testimony. And it does not, I see in the briefs the dispute on what the testimony established. And it seems to me that the better reading of the testimony is not that there was water in this spot in the store occurring with a regular occurrence. It seems to me the testimony established that water gets in the store and water gets in the foyer, however you say. And so I guess it goes, how do you define area, right? Like what, because this particular spot, it does not look like the testimony established that water occurred regularly there.
Mr. Wampler also said that there were times that the wet floor signs were placed in front of that set of doors. as
That
well.
does not establish, the fact that they put water signs in a particular apartment at some unknown interval does not establish a regular interval at which water occurs in the spot.
Well, we're not trying to establish, we're just trying to say, is there a question of fact here? And so,
Okay, but you gotta have some testimony that could at least a jury could look at to establish that, right?
yeah, I mean, yes, we do. And I think that with respect to the regular occurrence, I'm just struggling to see how a matter of
All right, so
2 or 3 feet can make a difference in where the customers are coming in and they're,
well, there's a set of doors there. There's actually a physical barrier, right? And one area is where people are much more likely to put a lot more additional water. Is that the first area they go into that has, a place to do the water, rugs. It's the first place they're shielded from the rain. So it's not just like it's an arbitrary 3 feet. It's actually a different defined area of the store. There's a structural barrier between the two areas, right? So can you address my question of if we look at this as the store generally, okay, just water gets in the store, which I think the testimony established. Doesn't that mean that if there was water anywhere in the store, they would be on constructive notice of it?
if there was a regular occurrence of water, I don't think that I don't think that what we're saying is that they have constructive notice of water anywhere in the store. We're saying that there's constructive notice of water near the front door, which is,
And I think what you've heard us say is we don't think the testimony established that there was water in the inside, outside the foyer, in the inside of the store area. We think the best case scenario of this testimony for you is that it was inside the foyer, right?
well, let me
So I guess
go on.
in terms of you establish, are those one area or two different areas? And it seems like they'd be two different areas.
If that's how you guys see the evidence, then I understand that. Then the other issue is the fact that it's within the site of the cashiers, which I think is a separate independent basis for constructive notice.
Did any cashier actually testify that they saw water on the floor?
That's not the standard for notice. That the standard is, are you in the proximity or vicinity of the area? And you could have seen it if you were doing what you're supposed to be doing. And that's what
But didn't they testify that they were in the area and they could see that area?
they
and
did
do you-
testify that they could see the area.
But there was no evidence that came out that they actually saw any water on the floor?
But that's not the standard. If we look at all the cases that we cited in our initial brief and our reply brief, the only thing the courts look at is were the employees in the vicinity of the incident that.
Which prong of the statute are you referring to?
So this is a element of establishing constructive notice.
So but
Proximity of the-
you've got a statute that tells us. Seems conclusively the ways we can establish constructive notice. And I agree, there was case law predating the statute that might have been different. We've got a statute now. Okay, and the statute, I think, was like 2011. It's not been around that long. I think I'll make misspoke the date. 2010, 2010, I think it should be right. So anything before 2010, that's not how we look at constructive notice for transitory foreign substances anymore. We've got constructive knowledge may be proven by showing A or B. So I need you to fit your case under A or B.
So we have the Heiser case and the Plot case and the Markowitz case. All of those cases talk about constructive notice. And all those cases talk about constructive notice with respect to employees being in the vicinity of the area.
Counsel, didn't all those cases involve some sort of an opaque substance, not clear water, that your client, who's immediately above it, assuming it was there, says she couldn't see it? So how could a jury infer that someone sitting over here can see it if the person immediately who just slipped on it can't see it?
But then we're weighing the credibility of the testimony. We're weighing the evidence to figure out who could see what. And that's not the
Yes.
function of a summary judgment.
Counsel, in order for you to look at whether they've seen it, don't you have to show that it was there? Like nothing in the testimony I see shows when this water occurred. We've got 70-some people walking through in the few minutes before she got there. We don't know when the water reached a level that somebody could slip on it. It could have been the person right before her 30 seconds earlier.
And again, the case law is very clear that how long the item was there when we're talking about constructive notice is not relevant. So if we
Well,
look.
hold on. I'm looking at 768-0755A. Constructive knowledge may be proven by circumstantial evidence showing that the dangerous condition existed for such a length of time that in the exercise of ordinary care, the business establishment should have known of the condition. Seems to me like the length of time is super relevant.
So if we look at the Bennett case, the Brooks case, the Kostopoulos case, and the De Leon case, they all talk about how the item got there and how long it was there is not necessarily relevant when we're talking about constructive notice. And so
Don't you argue in your brief that this transient substance was on the floor for a period of time and therefore the store was on constructive notice?
yes, we argue that the lack of inspection for 25 minutes when they knew that
How did they know?
when they knew that rainwater being trapped into the store, even on a normal rainy day, and Mr. Wampler said, we have to mop a lot. Sometimes.
But how did they know in this instance that
Well,
there was transient substance in that spot?
That's actual knowledge, and that's not what we're going under. We're going under constructive knowledge, which allows us to look at the lack of inspection, allows us to look at all the elements that we set forth in our initial brief.
Counsel, is your position that we can go outside the statute? Because I'm telling you, there's a statute with 2 prongs and you're telling me, look at things not in the statute.
I'm asking
Look
the
at standards
case-
outside the statute. I'm not bound by other DCAs. I'm bound by statutes. I've got a statute here that says there are 2 ways you can show constructive knowledge. I'm not gonna not comply with the statute. That's not a thing I'm gonna do. So there's a statute, there's 2 prongs. I need you to tell me which one you fit under.
The cases that we've cited are all after the statute's issuance. They all deal with constructive notice. There's
What's your
DCA.
best case?
I would say probably the cases that are, hang on just 1 second.
That post dates the enactment of the statute.
The McCarthy case. The De Leon case. And the Heiser, which is the district court case. And the plot case
All right.
and the Radke case.
You are into your rebuttal.
Thank you.
May it please the court, Ashley Leisure on behalf of Applee Westgate. Appellant is effectively asking this court to hold Westgate strictly liable for injuries from the slip but not a fall on a small amount of water that occurred during Hurricane Irma's landfall. This would be in contravention of section 768.0.
Counsel, can you just go through the cases he mentioned and tell me whether we need a certified conflict with any of them?
Sure. All of the cases that he cites in the reply brief with respect to proximity, that includes Plot and Heiser, which he just mentioned, are distinguishable. Those cases were decided under maritime law and not Florida law, and they all have additional facts in addition to the proximity issue. The
Sorry,
daily-
counsel, did you say all 4 cases are under
No,
maritime law?
No, Plot and Heiser are under the
Plot and
maritime
Heiser.
law. The other cases, De Leon, Bennett, Brooks, De Leon involved shopping baskets, and there was evidence of a recurring problem with those shopping
So you're
baskets.
saying it wasn't a transitory foreign substance?
Exactly, Your Honor. In Bennett, there had been evidence of repeated warnings about the slipperiness. So that would put it into the category of regularity of the condition. And in this case, there is no evidence. I think, one of the points that I wanted to touch on
Can you
was,
address McCarthy?
Oh, sure. I'm unfamiliar with the McCarthy case, Your Honor. I don't know what the full citation is, but that's not one of the ones that I briefed. I'm gonna be happy to supply information about the case afterwards. I don't know if the full citation, I'm referring to it by another name. The Brooks case, I think, was one that he also mentioned. That involved rain frequently, seeping in under the door, and there was a lack of warning cones in that case as well, so that also makes it distinguishable. I think one of the important points that I wanted to raise is, it goes to your point, Judge Mize, about the recurring issue. I think essentially what appellant is attempting to do is to draw an inference generally about existence of water in other locations and try to apply it to the specific location where Ms. Walton slipped but didn't fall. But I think that there is specific testimony to the contrary. Mr. Wampler testified that water did not frequently pool in that area.
I was gonna ask you, if you say this was like in an aisle store.
Right.
And the substance, water, whatever it is on one side of the aisle
Correct.
regularly. And everybody says, yeah, there's, for some reason, there's a leak, it always gets there.
Right.
And for whatever reason, you know, the leak spreads in the ceiling, whatever. One day there's some water, say 2 feet the other direction. And it's undisputed. Everybody said, yeah, there was water on the right side of that aisle every single day. Everybody, all the time. Well, yeah, it was just there all the time. Everybody knew about it, right? And now there's water 2 feet to the left on the left side of the aisle. Would we say that that's a different area so that the regularity wasn't established, even though that everyone said there was water 2 feet to the side regularly?
I see your point, Your Honor. I think you're suggesting that there's a limit to the specific area that we need to be talking
Yeah,
about.
how specific do you need to be? Like how do you define the area?
Well, I think under these facts, it's very clear that the area was separated by a set of doors and it had mat in front of it. That's not the same area as the aisle that's 2 feet away. I think logically or foreseeably, on an aisle with no obstructions, water could move easily from one place to the other, as opposed to here, in water inside a glass enclosure with double doors is not foreseeable to easily move outside of that. I think that's a separate area, and there needed to be specific proof that water was a recurring issue in that foyer. And in fact, Mr. Wampler said there was not. Ms. Harris said in the 12 years that she worked for the store that nobody had slipped there. So I think there's direct evidence contrary to the inferences that appellant is asking the court to draw, and I don't think that's permissible under Whitlow, Kemp, and Leftwich. I think also the testimony about the massive puddle of water, the court does not need to accept that. It's blatantly contradicted by the CCTV footage. You can clearly see that there's no water there until she comes back several minutes after her slip and shakes her umbrella and deposits water into that area. Again, I wanted to address the argument that the water is not visible, or the visibility to nearby employees. I think the case law is clear, and Your Honor is clear that that's no longer a factor that the court should be considering. Constructive notice can be proven exclusively 2 ways. One, that the condition existed long enough such that the business should have known about it, or it existed with regularity. Just being able to see the area.
What if it was on the border between the foyer and the inside?
I think that would be, a closer case, Your Honor, but I think here it's almost like there's a separate room, and it's hard to say, like, if there was a leaking air conditioner leaking in one room, would you expect that leak be transmitted to the next room over? I don't know that that's foreseeable. I think it needs to be the specific location or room in this instance, or aisle in your example.
Could you define the area as the place where people shake off umbrellas when they come in?
I don't think people are shaking off umbrellas in that.
There are people in the video, they're shaking off their umbrellas on the inside.
And it was also during Hurricane Irma, so people just sort of wet out,
So the inside is where people didn't stop in the foyer, shake, and nobody walked. Some people walked in a little bit through the foyer before they shake off their umbrella, right?
Of course, but I don't think there's evidence to support that was a regularly occurring incident that they were shaking off.
Well, it depends on how you define the area. If you define the area as the place where people might reasonably shake off umbrellas, and that's all one area, then it did happen regularly in that area, right?
Well, I mean, I think reasonably you would shake off your umbrella when you're coming from the outside and your umbrella is wet and you're coming into the
But
foyer.
people shook off their umbrellas inside. We saw that.
It's true, they did, yeah, but I still think that the area that is at issue, where the recurring problem was inside, where the mat was, where the cone was. If there was testimony that, you know, people were shaking things off outside of that, you know, obviously then,
Well, there's video.
but there's not testimony to support that that was a regularly occurring issue. And that's required under the statute. I wanted to briefly
Do
touch.
any of your cases deal with this issue of how we should define the area?
No, Your Honor, I didn't cite any cases specifically addressing the scope of the area at issue. Obviously, the legislature enacted the statute in 2010, so case law is still.
Yeah, you agree that's something we gotta do, right? When we look at the regularity of the condition occurred with regularity, we gotta define what is the condition, and therefore we gotta think about what is the area in
Right.
which the condition applies.
Of course, and I think here, if there weren't evidence directly to the contrary that it was not a regular recurring issue in that specific area, then appellant might have a better case for his position. However, there is evidence directly to the contrary. Wampler said, even on rainy days, water was not regularly accumulating there, and Ms. Harris also testified, over 12 years, no one had slipped in that location. So the evidence is actually contrary to the inference that appellant is asking the court to draw. I wanted to briefly touch on the Markowitz case, since that was highlighted in the reply brief. As Judge Mize recognized, that's no longer good law in the foreign transient substance cases. Obviously, the legislature has superseded the duty with the statute. The duty is now limited to constructive notice or actual notice as delineated in the statute. There's not a duty to minimize or prevent or any sort of negligent mode of operation, cause of action recognized anymore in transient foreign substances cases. I also wanted to briefly touch on the duty to warn. I think part of the issue or the problem with appellant's argument is that at the center of the duty to warn is the necessity for there being a known dangerous condition. I think this goes back to what we were discussing. There was no known dangerous condition at this location. And then there's the specific employee testimony that's clear on that to the contrary. I think the Scott, Dideau, and Brooks cases, which are also mentioned in the reply brief, are distinguishable. They all had evidence of testimony of recurring slipping or water accumulation at the exact location where the fall occurred. I think that the Adams case, which was decided under maritime law, not Florida law, is instructive to the panel. It does talk about the scope of the area at issue. It's probably closest to our facts here. There, the 11th affirmed summary judgment for the cruise ship. There was an anonymous internet posting that was complaining about a leaking shower in one of the cabins. However, there were no guest complaints about the specific cabin where plaintiff fell. And because of that, the 11th said that there was no genuine issue concerning the constructive notice.
Counsel, if we could just skip to a separate issue.
Sure.
Westgate raises that at summary judgment, you didn't ask, or your client didn't ask as to the duty to maintain the premises reasonably safe. Can you speak to that a little bit?
Sure. I think that it's clear from the case law. I think Owens, I block quoted it in the answer brief, specifically addressed it. That was the duty. However, with the legislature enacting 768.0755, it has eliminated that or superseded that duty. So there was no separate need to discuss the duty of reasonable care because it's been subsumed into the discussion of 768.0755. Adopting appellant's theory would be the equivalent of strict liability for transient foreign substances, and the legislature has explicitly rejected this. Businesses would have to patrol constantly for any liquid, regardless of the time that's on the floor, and that's not what the legislature intended with its enactment of the statute. The burden was on the appellant to show that there was a material, genuine dispute with evidence about constructive notice, and she failed to do that. If the panel doesn't have any more questions, I would ask the court to affirm.
Thank you. In conclusion, Judge, I would ask that you, consider the inference that water was tracked into the store. Everyone knows, it's conceded that rainwater is tracked into the store. The closed circuit television surveillance footage
Well,
shows.
I don't think anyone disputes there was water in the store. The question is whether they had constructive notice on it. I don't think it's even disputed that water was in this place and she slipped. The question is whether they had constructive notice of the water in the store.
And I think if we consider the fact that 70 people walked through that area, clearly in the footage, all the water is not being deposited onto a mat that's drying it in.
No, I know. The question would be, at what point did this condition exist such that she could slip, right? And we don't know how much water was coming off each person, and you know, you've got a burden to show that this condition existed, either existed with regularity, right? Or it existed for such a length of time. There's got to be some evidence by which a jury could say that's a sufficient length of time or regularity.
I just think we get into a real danger when we start trying to define things within feet, especially when we're talking about people clearly traversing an area where there's clearly and indisputably water. And 70 people in 20 minutes shaking off.
But Counselor, you say 70 people. I watched the video. So you have, from the video's perspective, you're looking toward you.
Right.
Farthest away are the doors from the outside into the foyer. Next are the doors from the foyer into the store. You're with me?
Yes.
When your client slips, video shows her basically in front of the door that is to the viewer's left.
Yes.
With me? Many of those people that you're talking about traversing this area come into the store or go out of the store through that right door. Correct?
Yes.
So are you saying that the jury could draw an inference that water, assuming that it was on any of those people, dropped from there and then went over to the area several feet away?
I don't think it's several feet. I think it's a matter of inches. And so
Do we have to see the water, or the jury? Does the jury have to be able to see water falling off of these people?
I mean, we're talking about when they zoom in, we're talking about grainy CCTV footage. We're not talking about, it's rain. Like we live in Florida. We know what rain does. And when my kids come in the house and they take off their jackets, or when my wife closes her umbrella.
We get it. This is an area where there could possibly be rain. Okay, I've got language of the statute. You've got 30 seconds left. What is the piece of evidence by which the jury could derive the length that there was enough water, length of time, there was enough water there for her to slip?
You look at the cases that talk about the lack of inspection, the cases that talk about employees being in the vicinity, and the inference that water was tracked from the foyer to the opening where Miss Walton slipped.
Thank you.
We would ask the court to reverse. Thank you.
Thank you. Thank you to both counsel for your arguments. And the next case is 24-2486, the Oliveira v. Naples. I'll give counsel a moment to get set up. Both counsel ready to proceed? All right, this is 24-2486, Oliveira v. Naples Golf and Beach Club. Counsel, again, 5 minutes is our default. Is that sufficient for rebuttal?
It is, Your Honor. Thank you.
All right, are you ready?
I am.
All right, please proceed.
May it please the court. My name is Daniel Schwartz. I have the privilege of representing Joannis Oliveira in this case, and like the other case, we're dealing with a constructive notice issue as well as an open and obvious defense issue. So with respect to the constructive notice issue, we think obviously that this case is controlled by Murphy.
Doesn't Murphy predate the statute, counsel?
It does.
Isn't that the biggest weakness there?
It does, but it still deals with a constructive notice issue. And the statute really is a codification of what happened in the common law. So it's at least persuasive.
Is it really just a pure codification or was it a limitation?
I believe it was a limitation, but I think it would still be persuasive in the context of what we're dealing here, especially given how analogous that the facts are.
Well, kind of depends on, well, it doesn't really depend on how the analogous the facts are. It depends on how well the facts fit under what the legislature intended to limit, right? Like if it's in with the, if the case is within what the legislature intended to preserve in the common law, then that'd be persuasive. If it's in the part the legislature was intending to limit, it would be the opposite of persuasive, right?
I agree, but I don't think that it changed anything that was different under the common law, because really what we're dealing with is.
You don't think the statute changed the common law at all?
Well, I'm saying with respect to the issues here,
All right.
that we're dealing with zone of risk issues, that's just general negligence, that hasn't changed at all. We're dealing with foreseeability of a dangerous condition. Nothing there has changed with respect to the common law. As to negligence.
All right, I'm not sure I agree with that, but let me just ask you, so. I was thinking about how to define the condition here, and your argument seems to be that. The dangerous condition existed because they could see these palm fronds rotting on the trees, so they knew they would fall. And that seems to me to not be knowledge that the dangerous condition existed, it would seem to be knowledge that circumstances are such that a dangerous condition could exist at some time in the future. If you see a palm frond rotting on a tree and it hasn't fallen yet, there's no dangerous condition yet. You just have knowledge that a dangerous condition may arise at some time in the future. Does
Well,
that make sense to you?
It does, but I think that goes to foreseeability. And again, the
Right.
knowledge that a general zone of risk is going to develop.
All right, counsel, I've got a statute.
Yes.
All right. Telling you, I'm looking at statutes. That statute says, dangerous condition existed for such a length of time that in the exercise of ordinary care, the business establishment should have known of the condition. So I need some evidence, and the regularity is separate. We can get to that if you want to move on to that, but right now we're under A, so I want you to respond under A. I need evidence of the length of time that this condition existed. Palm frond is on the ground. What is the evidence of the length of time that that palm frond was on the ground?
I would say that the best evidence is that there was a storm earlier and that it would have been blown down and that they had time to perform an inspection that it would, and it wasn't done.
All right, so that's not evidence that it was there because you don't know whether it fell during the storm, right?
Correct. It's an inference. Correct.
Yeah. So. But I mean, it's just. Yeah, okay. That doesn't tell you the length of time it was there. It allows you to speculate, well, maybe it fell during the storm, could have also fallen after, right?
It could have fallen after, but as the testimony of the employees established, there's a gap in when their inspections typically take place.
Right.
We don't actually have knowledge that the inspections did take place because there is no evidence of that.
But you've got a burden to show that the condition existed for such a length of time. So I get you, what you're trying to say is, well, they should have figured this out. I've got a statute here. Is there any, if the answer is no, just we can say no and I'll move on, because there's another part of the statute you can go under, right? But I'm not gonna let this go until I get a straight answer. Is there any evidence of the length of time this palm frond was on the ground?
I have nothing other than what I've already expressed.
Okay, all right. All right, go ahead.
So I can keep going under Murphy unless the court has any other questions about that issue.
I do have a question as to, didn't the arborist testify that the dangerous condition exists and concludes really once the palm frond falls on the ground? It only exists when it's still attached to the tree?
I think the only problem with the way he formulated it is that when it only existed. That's not really in what he said. He said the dangerous condition existed at the time that it fell. He did not exclude that it existed beforehand.
Is it dangerous when it's still attached to the tree?
I would say yes, because it's foreseeable that it could fall and
Not could it become dangerous in the future? Is it dangerous when it's attached to the tree? Is there a current danger at the time it's attached?
not to a pedestrian who's walking around in the park.
Not this type of danger.
Right.
And she wasn't hit by the palm frond,
It
right?
did not fall on her head. She tripped on it as she was walking at Fergie.
Okay. And so it's your position that the dangerous condition is the leaf on the ground, the palm frond on the ground?
Correct.
Okay.
Well,
Is there any authority, any cases that have, I know you said one case about palm fronds, those are falling. Do you have any other authority that other courts that have also considered that a dangerous condition?
Murphy is the only case that I'm aware of that has looked at palm fronds and how it.
I'm amazed there was a case just on palm fronds.
I was as well. It
And that was for a falling palm frond, right?
was a falling palm frond, but you know, it relied on the testimony of the arborist. And if you look at the way it was formulated, the only way constructive notice would work is if it was based on the timing of how long it had been there and attached to the tree.
Yeah, but
Because
this is a different condition though, right? The condition of it being on the tree and potentially falling on someone is different than it being on the ground and somebody slipping on it, right? Those are both conditions, but they're different conditions, aren't they?
No, I would say it's the same thing, because the condition is the palm frond of dying on the plant.
But counsel, that doesn't fall within the scope of the statute, right? The statute says, I mean, there's been a good focus for good reason on another part of the statute, but it starts with if a person slips and falls on a transitory substance. A hanging palm frond can't be a transitory substance until it's deposited on the ground, right?
Well, I would say
Transitory
if the transitory substance once it died, because you know it's going to fall, it's not going to come back to life and stay on
I
a
guess what
tree.
I'm saying
It's
is
just not-
your case, we've got a statute here that's specific to slip and falls.
Correct.
And your case not just predates the statute, it was not a slip and fall case.
It was not a slip and fall case.
All right.
I guess
Um,
going back to Judge Kamutz's question, is there a case that you're relying on that has held that a palm frond or any kind of vegetation on the ground is a dangerous condition under this statute?
Yeah, I would say field house. That's a
Which
case
one?
that field house. That was a case where there was a root.
Root?
I do believe that it also predated the statute, so I don't know if that would change the court's opinion on, but that was certainly a case where they found it was a dangerous condition because it was an area that pedestrians regularly use. It was foreseeable that they could suffer that, the same harm that they would suffer as if they were normally using the premises, and the court reversed in summary judgment on that issue.
Now, was this a root that had somehow been detached from its tree, or is it an actual still attached to the
It
tree,
was
but
still
above the
attached.
surface of the
Yeah.
ground?
That's the way.
That wouldn't seem to be transitory. A root matted to the ground is not transitory.
Yeah, I don't think it technically addressed the statute at issue, but I'm using it to show that there was a natural vegetation and there was an issue for the plaintiff when they were walking.
Do you have any cases like, say, wet lawn clippings, for example? That'd be a good example. They get blown all over a parking lot. You see people later with a blower to move them away. Anything about that?
I haven't seen any case on that one way or the other.
The other thing I was interested in brief was the regularity. And you basically say it was regular because palm fronds fall at various places. And I'm not sure just for palm fronds falling generally around around the place is a specific condition as opposed to palm fronds falling in a specific location. Because a palm frond in one area may be dangerous and a palm frond in another area may not be dangerous. So it seems like the relevant condition to me that you'd have to establish the regularity of was a palm frond in this location.
Well, it was localized to the parking. That's where the palm fronds were,
What-
that's where the
what-
palm trees were, that's where they fell, that's where they had the policy to pick it up and move it out of the way of the pedestrians.
Okay, so
And that's the other, I apologize, go ahead.
No, so your condition is, that's helpful.
Yeah.
You want to define the area as the parking lot.
Correct.
Okay,
And not only that, evidence of a corrective action is constructive notice, even under the statute. And we know that the hotel has a policy that they have to go through and watch out and pull them out of the way so that the pedestrian doesn't get injured. And so that's another method of imposing constructive.
I don't see corrective action in the statute.
If you look at the Brady versus Carnival and the other cases that we cited, that's evidence because, I mean, it shows that they know about it and they're trying to do something about it. And that's what constructive knowledge is.
All right.
How many times do they have to do something about it for it to be with regularity?
You know, I think that's undefined, and I think that's something that needs to be determined on a case by case basis. I don't think you can ever just simply say you need to do something X times and have a one size fits all kind of situation. So I don't think that's something that's been established. But here we know that they had a policy where they were checking or supposed to be checking every day. Whether they did that or whether they did not.
That anytime a business looked for something, say they went above and beyond, say something was a very rare occurrence, didn't happen regularly, say it happened once every 5 years, once every 10 years. This business is just has the most responsible management ever, and they decide even though no person on earth could say this happens regularly, I just want my resort to be the safest resort on the face of the planet, and I'm gonna look. They'd be effectively be punished for doing that, right? The fact that they were looking out for things, no matter how irregular they were, would be evidence of regularity.
Well, I think you can say it's part and parcel of it. So you can consider it in addition to the fact that they had something that was regularly occurring. It's just simply another prong that shows that they knew something was happening.
Well, where's the evidence that they knew? Point me to the evidence that shows how many times the appellees, employees, agents saw palm fronds that had become detached and fallen on the parking lot.
I believe he said it happened every couple months and he had been there for about 5 years. So that would have been the
On the
frequency,
parking lot,
my understanding.
not on the ground next to the parking lot, not over here by the pool.
Right.
Or by the golf course, whatever, no, okay. How many times?
Every 3 to 4 months for the past 5 years that he had been.
Can you address the point of open and obvious? Why wasn't this open and obvious condition?
So the issue with the open and obvious is, one, she has to be able to see it, and there's no evidence that she saw it. She testified she couldn't see it.
But whose responsibility is that? If she's operating and behaving, exiting a car using normal, reasonable prudence, wouldn't it be fair to say that she would have seen that palm frond on the ground?
I think it's a practical question, because if you look at the photo that we provided, that we embedded in our brief, you can actually see that the door is open and it's still blocking most, if not all, of the palm
Also,
frond.
anything is not open and obvious when you've got a barrier. I think the presumption is there, when people open doors, they look where they step. Right? I mean, so, yeah, anything, if you put a barrier between your eyes and the thing, anything will be open and obvious.
Well, exactly.
Right.
And there's actually a number of cases that talk about the issue where if you can't see it, you can't find that it's open and obvious.
But that's my point. If the reason you can't see it is because there's a barrier that a reasonable person is expected to remove the barrier and look before they step out. You see what I'm saying?
Well, it was open and you can see that it's still blocked even when it is open. So that's why you have to put yourself in her position getting out of a hot truck.
I looked at the picture. I didn't, with the door open, I didn't think that it was unable to be seen. I mean, with the door open, let me pull it up again. I'll look at the picture with you. I'm sure you got a copy of the picture. You put one in your brief.
I do.
Yeah, I mean, I'm looking at the picture. I'm just on page 3 of your brief. With that door open, I mean, it's not unable to be seen. I mean, there's a direct line of sight from where you would look down and put your foot getting out of the car.
So the door is at its max position open in that situation. I think, typically sometimes you're stepping out and opening it at the same time. That's a reasonable.
I don't think the door's at its max position. I think it's open the minimum amount it could be open for her to get out.
I would say we have to look at this in the light most favorable to the upon summary judgment, and when
Do I have to
that,
ignore my own eyes to look at the light most favorable to the plaintiff? I mean, I've got a picture here. It's. I mean, we do have to look at things in the light most favorable to non-moving. I don't think we have to look at things that could not possibly, by any stretch of the imagination, be accurate in favor of the movement. I mean, I'm looking at the picture. The door's not wide open.
can I offer one more addition to what I mentioned? If the court disagrees with me that she should have seen it, there has to be evidence that she appreciated the danger. And there simply is no evidence of that. And that's the Roccomonde and the Knickerbocker case. And I want to talk about the.
Doesn't that
Knickerbocker-
get back to the point of, is this a dangerous condition in the first place?
No, it shows whether she has to appreciate whether the condition was dangerous for her. For an open and obvious.
So it's a
offense.
subjective test?
It is a subjective test.
So
And-
I saw those cases, and here's my question about them. It seemed like in some cases, the transitory foreign substance, basically the substance or the item was visible, but how trippable it was, for lack of a better word, was not apparent.
Correct.
Right? And so it seems to me that would rely on there being an item that at least when you can look at, you could realize, not immediately realize is trippable. Right? Like I think there was one item that was like in an aisle that there was a piece sticking out that you wouldn't see.
That is part of it. There's also a case, which is the Knickerbocker case, where it was a doorway and there was like a threshold step. And they stepped through it, and I think the plaintiff actually testified, he saw it, he said it was obvious. He used those words in his
It
testimony.
wasn't obvious I could trip over it.
No, he said that the door sill itself was obvious, that the object was obvious. And the court said that wasn't enough for summary judgment, because the dangerous condition of the threshold was not obvious.
No, fair enough. I guess what I'm saying is, there are some conditions where the dangerousness might not be apparent, even if the item itself is. And then there are some conditions that the item itself would just be. The dangerousness and the item, how trippable it is just obvious, right? So doesn't that rely on kind of the item being something where you could notice it with the dangerous nature, the trippability, right? Not being obvious?
I'm not quite following the question.
Wouldn't that have to be some type of object where even if the object itself is obvious, the trippability or the dangerousness of it is not?
Well,
You can have items where the object and the trippability are just synonymous because it's just obvious that it's trippable.
well, I would again just go back to the Knickerbocker case. I mean, you would think that an obstruction in your doorway would be something that would be obvious, and the court said, no, it's not. You do like most favorable to plaintiff. It's something that needs to be resolved by a jury. So I think it depends. You know,
Sorry, Cal, what was the name of that case again?
the Knickerbocker case.
Can you just go into a little bit more? You said that the standard would be subjective if it was dangerous for that person specifically. Is that,
Well,
go into that a little bit more?
and I apologize. When I say subjective, I mean taking into account all of the circumstances of the attendance situation. So again, the open and obvious defense requires you to take a holistic view of everything. That's why I brought up the issue about stepping out of the car. You're not just, you know, when we look at the photo, it's easy to say, well, yes, I can see it right here. But it doesn't take into account what she was doing in that situation where she was stepping out of a car and taking.
But the standard would be how a reasonably prudent person would behave in that situation, right?
No, it would be how Miss Oliveira or someone in Miss Oliveira's shoes at that time. Yes.
A reasonable person in her shoes. right?
Yes. Yes.
Yeah, so from her perspective, but a reasonable person from her perspective.
Agreed. Yes.
Her physical perspective, but not her actual person.
Yes.
If she's not entitled to act unreasonably.
Right.
Counsel. Counsel.
Thank you, Your Honor. May it please the court, my name is Michael DeLugo from the law firm of Wicker Smith here in Orlando, and I represent the Naples Beach Hotel, which I will refer to as Naples. Yeah, I can tell from the questioning that the court is fully aware of all the facts in this case, so I'm not going to delve into too much of that. But one key fact is the affidavit of the expert witness that the plaintiff offered, the arborist, Mr. Samnick, in which he testified that the subject frond was a dangerous condition that existed when it failed. And that's at page 187 of the record. And so it's our position that the dangerous condition was the palm frond on the ground, and that there is absolutely no evidence in this record as to when that palm frond fell.
Counsel, I thought, I took your point as the affidavit and I read it in brief. I thought what he said about the parking lot was interesting. Can you talk about the regularity? Because I think defining the area is important. Right? I think if a palm frond regularly fell 3 inches over, you wouldn't say, well, it doesn't happen regularly. It was 3 inches to the left, right? You'd say that's the same area. And so they've defined the area as the parking lot and said that there was evidence that palm fronds regularly fell into the parking lot. Can you respond to that?
Sure. Now, I'll defer to in looking at everything in the light most favorable to the non-moving party, in this case, the plaintiff appellant. If you look at the parking lot is the area, the testimony still only says or only shows that this would occur every few months. The testimony is from the security officer, Mr. Daniel Kazmerzak. And he said that
That's an interesting thing because regularly, I'm not sure it denotes a specific frequency, it just promotes regularity. Like if something happened once per year, every year on the dot at the same time, you would say that's a regular occurrence, right? Regular kind of doesn't necessarily denote a specific frequency, does it? Or like a very high frequency, just that it's regular. Like if something happened every 10 years, would that not be regular?
sure, Haley's Comet is regular.
Yeah, every
Yeah.
75 years. So that's my point. You say, well, he only said it happened every few months.
And it's random. It's around the entire property. So we're not talking about a specific location. We're talking about the parking lot in general. But there is no evidence to suggest that there were palm fronds that would regularly fall at this location.
Did it then, and by this location, you mean the parking lot?
No, by this location, I mean where Miss Olivera fell.
All right, I'm asking you to talk about the parking lot. What is your view of the testimony?
The
as to-
testimony of
as to
Mr. Cas-
Pomfrons falling in the parking lot.
Every few months is what the testimony was from Mr. Caspernet. So, and again, looking in the light most favorable to the plaintiff, looking at if you're going to define the area as the parking lot as a whole, that's the testimony, is that it occurred
Every few months, not regular?
Well, it's random though. It's not something that happens on a specific,
You didn't say
location.
it was random, you said every few months. That seems like a specific interval, doesn't it?
So every 3 or 4 months they're doing a daily inspection, looking for these things, and clearing them out when they, the testimony is if you see it, grab it and get it out of the way. They have a crew that comes in, I think pre-dawn, every day and inspects the parking lot, removes the palm fronds. So again, I go back to when did the dangerous condition come into existence? When the palm frond fell?
Well, that's A. I hear you on A. I'm wondering about B. Right?
And I don't think-
You don't have to show the length of time it was there if you show it occurred regularly. And I guess what I'm saying is if you got testimony saying, well, it's every few months, is that not regularly?
I would say under the facts of this case, no, that is not regular. That doesn't satisfy the regularity prong of
Why?
the statute. Because it's random. Okay, yes, you say it's every few months, but
But you're saying it's random. He didn't say random. He said every few months.
that's correct. And I'm qualifying that and saying that what he's saying is every few months is in fact a random occurrence. It does happen with
Let me follow
regularity.
up with that and then follow up with Judge Mine's question as far as the regularity. So this arborist, did the arborist testify that every few months, that was the nature of the palm tree, that they shed their fronds every 3 months, for example?
No, that was the testimony of the security guard or security person, employee of the facility, talking about how frequently palm fronds would become detached from trees on that property.
And was it attached to some sort of, was there some testimony regarding why that happened? So I guess your answer to my question is, was there testimony that this was something in the nature of this plant that happened as part of the plant's natural life? You're saying there's no evidence of that.
I don't want to state unequivocally that there's no evidence of that because I'm not exactly sure.
I think what you're saying is he was speaking kind of colloquially, right? Like if he had said this happens every 3 months on the dot, you would probably agree that's regularly.
Right.
And I think what you're trying to say is what he meant by every few months was kind of every once in a while, not absolutely on the clock every few months.
Correct. It's actually a
Is
page.
Is that two different ways to read the testimony though?
I'm just going to draw your attention to page 400 and 401 of the record, which is the testimony on this issue by Mr. Kazmierzak. And again, you're right. It was sort of an informal colloquial conversation that was going on during the deposition. That he testified that it would be months between palm fronds falling. That's the testimony.
Did he attach it to anything like, say, rain events, storm events?
He did not.
Thank you.
So going back to prong A, there's no evidence of when the palm frond fell. And as to prong B, we would argue that this was not a regular occurrence. And as an alternative conclusion, the trial court found that this palm frond was open and obvious. And the issue, I think, for this court is established by the Early versus Morrison cafeteria case. That's a Supreme Court case from 1952. I know it's an old case, but it's been reaffirmed. This issue has been reaffirmed.
Reaffirmed or not, that's unless they've overruled it, we gotta follow
No,
it.
that's true.
What was the
And
name
that-
again, counsel?
Early,
Early?
versus Morrison Cafeteria, 61 Southern Second, 477. And at page 478, the Supreme Court stated it is equally well settled that the proprietor has a right to assume that the invitee will perceive that which would be obvious to him upon ordinary use of his own senses. And so I think that's directly pertinent to this case here. Miss Olivera, when she got out of her car, she opened her door. She had to open the door to be able to get out. And once she opened the door, she should have perceived the palm frond using her ordinary senses.
Does
And
everybody always look down when they get out of their car? Do they always like, if they stop in a parking lot? Do they always look?
I can't
right
speak for
outside?
everyone, but
I mean, wouldn't that have to, in order for us to send that, wouldn't that mean that an ordinary reasonable person looks outside their door before they step outside of a car?
I think that a reasonable, ordinary person would watch where their foot, where they're stepping when they get out of a car, where they're walking. And you know, that's what these, you know, the
That was
numerous
the case,
cases.
would there not be slip and fall cases?
I'm sorry?
If that was the case, wouldn't there not be slip and fall cases?
Well,
Everybody
I mean,
always is expected to.
if
see
there's a
the
dangerous condition that is unknown to the plaintiff, but that again goes to, you know, the statute that we've talked a lot about this morning. That sets forth the parameters of what you have to demonstrate for there to be liability. Yes, there absolutely would be slip and fall cases if the business owner runs afoul of the statutory provision that we've been talking about, doesn't conduct regular inspections, you know, does not, you know, take action when they have actual notice of something, and you know, allows a dangerous condition to exist for a certain period of time. You know, that's when you would have liability. So it's not that we would never have. You know,
I think your argument was
cases.
even if A and B, you know, were met, that you get to open and obvious, right?
I'm saying they're alternative theories.
I know, I think what you're saying is though, that you went under either.
That's correct.
All right, so that means that open and obvious kind of has to stand alone, that even if you lose under, you know, constructive notice, you should nonetheless win under open and obvious, right?
I have to win on either.
Yeah,
If I win on either, I win.
yeah, correct. And so kind of your open and obvious assumes you lost on constructive notice.
No, I'd like to win twice.
Okay, all right, but what I'm saying is the open and obvious has to stand alone. It has to be that it can get you out of liability even when you had constructive notice, right? That's how, that's.
That's correct.
Okay.
If the court finds that, you know, we lose on the regularity issue, we can still win if the court
I know,
finds
so
that it's
take,
open
you
and
know, take
obvious.
some laundry detergent in the, you know, in the line, in the aisle at the grocery store. If the answer is, well, everybody should always be looking where they're walking, nobody would ever be able to sue for slipping on the laundry detergent, right? Like, if you're just saying she should always notice. anything in
If
front of
there
her.
is, you know, I'm saying that when you're getting out of a car, you watch where you're putting your feet. If you're in if you're in a supermarket and there is a transitory foreign substance that has been on the floor for a certain period of time, and that period of time has been established, then the business owner can be liable under those circumstances.
All right, so I guess what I'm saying is your argument as to open and obvious relies on us finding as a matter of law that somebody getting out of a car, a reasonable person looks at the ground before they step out of the car.
That's correct.
Do we also have to find that, let's say we agree with you that a reasonable person should look where they're stepping as they get out of a vehicle? And had she done that, she would have seen the palm front. We also have to find, you have to establish that she could appreciate the danger caused by that palm.
That would be, that, you know, yes, we would have to show that.
So what's your argument? Because counsel makes that argument as well, is that even if we find she should have seen it, her looking
It's not
the wrong place
right,
doesn't
it's not-
matter because it wasn't open, the danger wasn't. And he cites the case, I think it was Knickerbocker, about the threshold.
Correct. In order for my client to prevail, we would have to show that not only was the palm frond an open and obvious condition, but that it's dangerousness.
It's trippability.
It's trippability. I've not heard that word before this morning, but yes, it's, you know, the danger that it may cause someone to slip and fall would also have to be perceived. That is correct. I agree with that. And I think that this, on this record, that shows that that's what the trial court concluded. And I think that the trial court was right in reaching that conclusion.
And what are you relying on for that aspect of it, in terms of in the light most favorable, what the evidence shows?
You know, I'm relying entirely on that picture.
Does it matter whether the palm frond is wet or dry?
I believe the testimony from Ms. Oliveira was that it was wet.
Does it matter whether the parking lot was wet or dry?
I don't think so, because the parking lot itself is not a dangerous condition. It's the palm frond itself that's a dangerous condition.
But she said it was wet, because she knew, because she slipped on it. She didn't say she could tell it was wet before she slipped on it, right?
That is correct.
So the wet nature, there's no testimony that the wet nature of the palm frond was apparent.
Well, she was aware that it had rained. She did testify to that it had rained earlier during the day. So I think, you know, yeah, she was aware of the wetness of it.
Does it matter that the parking lot appears to be asphalt?
I don't believe so.
So the open and obvious nature of the danger would be the same for wet asphalt as it would, say, wet terrazzo floor.
I mean, I'm not aware of any part of the record that would speak to that. So we're going-
Visually, do you think a reasonable person looking at that parking lot might think that it has a high coefficient of friction and it's not really slippery?
Well, I'm not sure that that's relevant though, because we're talking about the palm frond, not the surface of the parking lot. At least there's no testimony, there's no expert testimony that talks about coefficient of friction and, you know, raises issues like that. The testimony is simply the palm frond was on the ground. She should have seen it when she opened the door to the car. I think that the picture does show that she certainly had the ability to see it. And I also want to point out that she never testified in her deposition that she couldn't see it. She said.
Did she testify as to whether her foot moved on the palm frond and the palm frond remained in the same spot on the parking lot, or whether her foot and the palm frond also moved along the surface of the parking lot? And follow-up question to that was, if so, does it matter?
I believe it was the latter, and I don't think it does matter under these circumstances. Her testimony is, quote, "And as soon as I opened the door, I didn't see any, you know, I can't see. I opened the door, I walked out, and I slipped on wet palm trees." That's at page 113 of the record. And then on the following page, she stated, quote, "I was normal as soon as I got out of the car, just opened the door, just come off the car, so I guess holding the door." That's at page 114 of the record. There's no other reference in her deposition of her view being blocked, obstructed, or that she could not see. That appears nowhere in her deposition. So I think that just looking at that picture, it demonstrates that when she opens the door, she can see the palm frond. And she, I think, you know, as the trial court ruled, and I would ask that this court affirm that she should have appreciated, using her ordinary senses, she should have appreciated the danger that palm frond presented, and that she should have avoided it. And unless the panel has any further questions, we'll rely on our brief, and we would ask that you affirm. Thank you.
Counsel?
So I'd like to pick up right where he left off, and that's with the discussion about stepping out of the car. And I think an ordinary reasonable person has a right to expect that when you're stepping out into a parking lot, as the court said, you're stepping out onto asphalt. You're not necessarily expecting to step out onto a large wet palm frond. It's just not something you normally see. So that's why there's a question of fact on that issue. With respect to the open and obvious defense, that only applies to the failure to warn claim. So even if we prove constructive notice, and he prevails on the open and obvious defense, we still get to go down on the failure to maintain claim. I just want to make that clear.
And so you've got a couple minutes left, this idea of regularity.
Sure.
And the testimony of the maintenance worker as to regularity was every few months, or forget the exact phrasing. Give me your best minute 52 seconds that shows regularity.
I mean, 3 to 4 months for 5 years.
There's a reasonable reading of that testimony was that he was giving kind of a fixed time frame that it happens.
I mean, his testimony is his testimony. That's all I can say. If he's saying it happens every 3 to 4 months for the 5 years, that's 4 times a year for 5 years. That's 20 times before this happened. I would say that meets the threshold of regularity, or at least enough to go to a jury because there's a competing inference of fact on it. Unless the courts have any other questions, I'll leave the rest of my papers. I'm going to ask the court reporters.
Thanks to both counsel for your arguments. All right, we're going to take a brief recess.
All rise. Seated.
All right, good morning again, and we are here for our third case, which is 24-0997. Fernandez v. American Multi-Cinema. Both counsel ready to proceed? All right. Again, counsel, 5 minutes is the default for rebuttal. Is that sufficient?
Yes, Your Honor.
All right, please proceed.
Thank you very much. May it please the court. My name is Andrew Harris on behalf of the plaintiff appellant. Not a constructive notice case here after the two arguments this morning. But the central question presented on appeal is whether the trial court erred in allowing the cross-examination of the plaintiff's treating physician regarding the fact that a trial judge, in this case I call the Salazar case, had concluded that he had given false testimony under oath. For 4 different reasons, it's our contention that the trial court erred and that it was the defendant is unable to establish.
Because I don't know, I thought you made a really compelling argument that this was error. Okay, I didn't find the fact that the order had been vacated compelling, but I just don't see the trial court's finding of dishonesty as listed in 609 or 610. It's just not in there. Maybe it should be, it's not. So can you just start with the harmless error issue? Because I think the appellee's argument as to harmless error, I think they made some compelling points. You know, the doctor testified primarily on causation, and the jury found in your favor on causation. So how can the error be harmful if the issue he testified on you won?
So the first things first is the burden is the other way. It's not my burden.
I know, but I just tell you an argument as to why the burden is met. I agree, it's their burden. You've got me there. I agree, it's their burden. But that argument being made that, hey, how can it be an error if they won the issue he testified on? How does that not meet the burden?
Sure, Your Honor. The fact that the jury found causation of an injury does not get to the issue of harmlessness or harmfulness, because the treating physician's testimony was based on the causation. He had a surgery performed, for example, Dr. Rausch, $71,000 for a past surgery. This, when a jury hears this is a finding of a trial judge that you've given false testimony under oath, And it wasn't isolated. It, you know, the whole question was read out. It was mentioned twice in closing argument. And you go, well, just because we got past question one, causation of an injury, that arguably wasn't even related to Dr. Rausch at all. That was, you know, they fought heavily on whether there was negligence in at the movie theater. They found that they awarded $5,000 for past meds, $5,000 for non-economic damages under the special test, that there's no reasonable possibility that this testimony contributed to the verdict. I would submit that the defendant is unable to establish that here. You take a look at, I mean, it's the nature of, this is not just like one of the cases that I studied from the 4th District, the Strasser case. And that was where there was deposition testimony of a star witness lying under oath. We don't know the nature of that, what the lie was. But here it's one step further. This is a finding that a trial judge has found that a witness treating
I
physician.
get, that goes to whether it's an error, right? I'm asking about harmfulness of the error.
Well, that goes to the harmfulness because of the credibility of that witness regarding what? The nature of the injuries. Dr. Rausch testified that there's a permanent injury, for example. Dr. Rausch testified.
On that point, so his test, where that would come in is kind of the before and after, like how much of this injury was caused by or resulted from the fall, right?
Yes, I mean,
And one thing that struck me about his testimony was that he didn't purport to have any personal knowledge of the before condition. He just read the medical records, right? He didn't examine any of the tests himself. He didn't look at the MRIs. He didn't purport to. And so as to the before and after, he was just reading from the records that the jury had themselves. His credibility wasn't really an issue for how much the condition changed because he didn't purport to have any knowledge of how much it changed beyond reading what the jury itself could read, right?
that's fair, but the jury, of course, is given an aggravation of a pre-existing injury condition. And so Dr. Rausch is, from the plaintiff's perspective, and this is for a jury, you don't need to have testimony. Now, that's fair impeachment, that's fair, they're experts, but from an aggravation of a pre-existing
But
condition.
aggravation goes to how much it was damaged before versus after, right?
Well, I mean, by definition,
How much worse did it get as a result of the fall?
correct.
And so that's a result of a comparison between the before and the after.
Not, I would just say not entirely, because from a plaintiff's perspective, the purpose of the aggravation condition says, even if you had that condition before, right? You have.
But it had to get worse, right?
Well, it has to.
Okay, so how worse it is after the accident or the fall is based on what it was before and what it is after, and the delta between those two things, right?
Yeah, yes, I mean, but when you boil it down to that, I understand that, but the fact that a witness is only testifying, well, this incident has caused the need for what? For the surgery I performed. If a jury, you have this devastating impeachment, the jury could have entirely and it's not our burden, but for putting aside the burden, the jury could have
It's their
discounted.
burden. You have to keep it, it's their burden, I stipulate.
The jury could have just discounted Dr. Rausch and said, we're not awarding for any of it. Because he's a liar. A judge has found that he testified in a row. That surgery is what? Unrelated. We're not awarding any damages for that. So
But
that's
they
like
didn't do, counsel, they didn't do that here, though. They found that there was negligence, causation, and then they did award damages.
they did award $5,000 in past medical damages. And it's not our burden to have had an itemized verdict, right? There's no suggestion of that under any scenario, right? I'm sorry, Art, go.
But Judge Mize's point is well taken, where you won at below, and if this is your, witness going towards causation and negligence, understanding it's an aggravation case, what is it that you're saying that this testimony then led to harmful error?
I would respectfully say that we didn't win, though, because the jury is awarded, if the jury had awarded $112,000 of past meds, and there may be a tougher analysis here in terms of putting on me, how do I show harm? If the jury had awarded Dr. Rausch some portion of his medical bill here, we don't have any indication of that. So $5,000 most likely didn't include his surgery at all, didn't include his treatment at all. It included what happened. You had an accident, you go to the doctor, injections or whatever. And so the most likely scenario is that the jury didn't award anything for Dr. Rausch. I would say by by definition, that makes it,
But aren't they instructed, you alone can assess the reasonability of how much damages should be awarded, and they in fact awarded 10,000?
well, 5,000 for past meth and 5,000 for past non-economics, yes. Yes, Your Honor, but that doesn't go to the harm. To me, that just amplifies the harm, the fact that the jury didn't award a meaningful amount of past meds, awarded nothing for the future at all, because you have a witness with this devastating effect. And that's why I know it only goes to, you say whether the issue of whether there was harm, but you do have to look at the nature of what that testimony is. That is, and from my perspective, relevant to the harmless error.
But I'm interested in the nature, right? Because
Interested in what, I'm sorry?
I'm interested in the nature of his testimony, right? Because the nature of his testimony for all of the before condition was just to relay just to relay what's in the medical records that the jury had and to relay things the plaintiffs told him. Nothing about the before testimony relied on his credibility. He didn't purport to have any knowledge of it. He didn't even pretend he had knowledge of it, which is fine. He just didn't. That's just not something he purported to do. And so his credit as to the before and after, he had no credibility to be at issue on before and after because he didn't purport to have any knowledge of the before. He didn't purport to have any knowledge of the change from between before and after. Am I wrong?
You're not wrong in terms of the after, but to focus on the fact that his testimony is on the after, the jury very well awarded none of the after because of the because the jury heard that he gave false testimony under oath, and they actually had this, so by there
was a lot of other testimony as to the after part. His testimony only concerned, at least as far as his credibility is concerned, because that's the only part he wasn't just relaying other people's thoughts, was what was the condition of the neck after the accident, right? A lot of other testimony about that, right?
Yes, Your Honor, but
Like a bunch of people.
yes, but this is exactly what the Supreme Court, it's by coincidence, I had the special case in this is exactly what the
You argue
court,
special?
I didn't argue it, I briefed it. My boss at the time argued special, but that was an issue that was percolating in the DCAs for 15 years. And I can distinctly remember and saying that this is not a pro plaintiff, this is not a pro plaintiff, this is not a pro defendant, but the Supreme Court, they declared no reasonable possibility that this contributed at all to the verdict. So by definition, if the jury may have awarded $10,000 for that surgery, that is by definition entitlement to a new trial.
Let me ask you this. So what would the cutoff be? Say if he was the only witness who testified as to the before, you'd see one end of the spectrum. Say there were 50 and he was just one. And the jury just didn't believe any of the 50. Would we still say, well, he might have been the one to push him over the edge? I'm just, how do you define that? Is what I'm saying. How do you look at that spectrum?
We don't know. If you had a car accident case and you had 50 witnesses and the issue was only who caused the accident, and you had 50 witnesses and one of those 50 witnesses came in evidence that they had given false testimony in oath. And I think this court could say, well, you had 49 witnesses who said the light was red. And this one, the 50th witness who said it was red, a court probably wouldn't allow 50 witnesses for cumulative.
Maybe they were in for 50 different reasons, but they all happen to touch on that in their testimony, right? You wouldn't call 50 witnesses just to say the light was red, but maybe they had 50 different perspectives, right? For whatever reason, they had 50 different people. All 50 said the light was red. Jury finds light's green. One of those witnesses was found by court to be a liar. Would we say that was harmful? Because, well, they might have believed that 50th one.
I think under that scenario, you could find there's no reasonable possibility that 1/50th contributed to the verdict.
Correct. So you agree there is an amount of testimony you would reach and a number of witnesses where you would say, this one extra witness, we can be confident beyond a reasonable doubt did not make a difference on that jury finding.
Right. There comes a point where the harmless error
You just
test
don't
can
think
be
we
met.
reached that point.
No, because we don't have an itemized verdict here. We don't have an award of medical damages. We have this nominal,
What we have is the jury just wholly rejecting the notion that there was a significant harm as a result of this accident.
Fair. And a reasonable jury in a retrial could determine that, but that is not the stuff of the harmless error analysis. I readily conceded in the initial brief. They have very strong defenses here. They had their experts. This is a very defensible case. We could have 5 future juries reach the same result, but that is.
I guess what I'm saying is you agree, you conceded there's a spectrum, right? Which I appreciate. How far do you have to go on the spectrum? Do you have to have 10 other witnesses, 5 other witnesses, 3 other witnesses? You conceded 50 is enough. How many is enough?
Well, this is not a situation like the car accident case. This is a specific doctor who's testifying. I performed this surgery. It's related to the accident. I think we have a pretty good assessment. The jury did not award for that surgery. If the jury had if we had some semblance,
Did anyone other than Dr. Roush testify that this was a reasonable and necessary surgery for your client?
I don't know that offhand. I don't know offhand. I know there was other medical causation testimony, but it was not 49. I'll check that. And when I come back and rebuttal, there were not 6 other. First of all, he's the one who performed the surgery. It wasn't like his co-surgeon or whatever, testified about that surgery. And so even if there's other causation testimony from the plaintiff's treating physicians, if we're just focused on the harmless error test, this surgery, the jury may have found that this surgery was related to the accident, but for the devastating impeachment. I think that's a reasonable, there's lots of other reasons.
Did any other witness testify that, I'll just use the ballpark, 71,000 was the reasonable amount for the surgery other than Dr. Roush?
I don't think so. I don't think so. But this would be a much harder case. I don't think I would be here if the jury had awarded $112,000 in past meds and some amount in future meds. Then we're getting into, well, maybe the jury would have awarded $1 million. Maybe it becomes
a
a
record where that 5,000 came from, such as the number the jury picked up on their own. Was there something in the evidence that would have made them latch on the $5,000 figure?
I did not parse if that's like the initial 2 weeks of
Yeah.
bill. That part, I didn't make that connection. There are times where verdicts are right down, they excluded, that kind of like it jumps out of the page. Probably a reflection of a jury compromise of some type regarding, but what we do have I think a pretty good assessment is that the jury did not award for Dr. Roush. And so that is where the harmless error test, from my perspective.
Was he the only witness that testified to future pain and suffering?
I don't think so. I think the plaintiff had another treating physician who testified as to future pain and suffering.
Okay. Was there
Or
any,
the nature of the future, condition, yeah.
what about any other evidence to negate that there was no need for future costs or treatment?
Well, certainly the defense had their experts who testified to that.
Okay, so there is okay.
Yeah, absolutely. And that's if we were in a pre-special world and there was I know it's not about the burden or whatever, but this is exactly where to go. The defense had strong defenses to make in this case, but that does not establish harmless error.
So you had at least one witness testifying for future pain and suffering, and then there was, so in theory, could, to Judge Mize's point, supplement or complement Dr. Roush's testimony, right?
Right. I think that's a fair assessment. Yeah, I think that's accurate. But the fact that there's another witness, and I think the case law is the fact that you have another witness. I mean, there is some case law which talks about cumulativeness, right? And the special and not the conflict in the case law, but the conundrum or whatever, where you have, if you have cumulative testimony, is a trial court's error regarding one, does that now satisfy the special test? And in a car accident situation where you have a concrete issue like that of liability, I just think here that I understand when I say parsing that you're doing, I don't mean that disrespectfully or whatever, that's your job to do. But it jumps out on the $5,000 jury award. By definition, that's where the harmless error test crumbles, because the jury, they had lots of other reasons, but one of those fair reasons why they rejected is because they found the plaintiff's treating physician to be a liar and having given false testimony under oath. And so I don't presume that it was error, but if we presume for the moment that was error, the trial court erred in admitting that, the harmless error test has not been.
Hypothetically speaking, how do we know that the jury rejected Dr. Roush's testimony completely? Because again, there's the liability, there's a causation, and then there's a damage aspect to it. If we were to believe, okay, the jury believed him as to negligence and causation, questionable as to damages, how would we deal with that?
We don't know, but that is what the Supreme Court said is that's not the analysis that we're supposed to do. It's not, I, as the appellant or whatever, you know, if I'm able to establish error that was introduced by the opponent, that's the opposite of the harmless error test to go, well, maybe the jury didn't reject Dr. Roush. Maybe there were other reasons. There could have been very good faith. Well, I mean, the jury's always in good faith, they speak, but lots of other strong defenses that the defendant had. And maybe the jury just felt the pre-existing injury, or he wasn't, or she wasn't really injured, or she didn't need, you know, there wasn't a need for future. Those are all colorable defenses to make in front of a jury. But we never had the opportunity at that fair trial in the first place because of this devastating impeachment. And they're unable to establish, you know, any reasonable possibility, you know, they have to establish no reasonable possibility.
And the questioning just took place over basically like 2 pages and then mentioned once in closing. Is that right?
That's correct. It was mentioned twice in closing back to back. But
It was interrupted by an objection and then
repeated.
completed,
And then,
right?
and then the phrase again, right, that the court said noted for the record, fair enough. The other.
That was the extent it was brought up.
That is the
Right,
extent
okay.
that it was brought up. If I can just, and I know I'm eating my time, the trial court before trial said, well, this will just be one question. Has there ever been false testimony? And he'll just answer yes, and that'll be it. The problem is, and that goes to the nature of the vacated order, is that Dr. Roush truthfully answered, no, this is a vacated order, which is void. So it was not just an isolated question. It then led to opposing counsel reading the entire discussion from a vacated order from a trial judge, which was a non-evidentiary hearing, mind you, after trial, which the third DCA vacated that order in full to reinstate the verdict. And so I understand you may the strongest part you may feel is not the part that it's vacated, but at bottom, this is a void order, which never existed in the eyes of the law. It had no place in this trial, and the defendant is unable to establish under the harmless error test. I see I'm way into my rebuttal, I think. Thank you all very much. Yeah.
Counsel?
May it please the court, Jack Ryder on behalf of the Appellee American Multi-Cinema. I'll briefly discuss the issue of whether or not it was in fact erroneous. I believe that
Is the trial court's finding that somebody was dishonest, is that one of the types of permissible character evidence listed in 9609 or 96?
dishonesty is not.
All right.
It is not. But I would respectfully submit that this can also be interpreted to go to bias. And I do submit
How?
that
No.
here's how. When you have a doctor who acknowledges that he has I guess either a letter of protection or is waiting for a verdict in order to recover his medical bills, which Dr. Roush did admit, I think it was $71,000. When he acknowledges that he has testified for the law firm before and will expect to do so in the future, when he has in the past.
All those things go to bias. Why, we're talking about the finding of dishonesty.
Sure, and I think specifically, it was the fact that he has a motive in order to provide testimony that is helpful to the plaintiff and had done so in the past and was found to have been dishonest in doing so. Well, he was found to be dishonest in the past, but he has a motive to give testimony in favor of this plaintiff.
So in other words, you're saying all doctors who are owed bills and testify are biased, right? But this guy had evidence he was willing to lie for his bias.
I believe that that is what the trial court was thinking, and I believe that is a discretionary decision by the trial judge. And again, when one looks at when the
Counsel, I'm sorry, I just want to make sure that
Sure.
I'm understanding what the record shows. I'll refer to the prior order.
yes, sir.
In the case involving the prior order, was the plaintiff's counsel in that case the same as the plaintiff's counsel in this case?
No, I didn't, and I don't believe so, and I wasn't suggesting that.
Was the plaintiff in the case involving the prior order the same plaintiff
No.
as in this?
It was not.
But I guess what you're saying is the actual bias items you mentioned apply to every doctor owed bill, right? And so what you're saying is that this showed he was willing to lie for his bias, which that's evidence of character.
I understand, Your Honor, but my point is that I do believe that inquiry, the inquiry to the extent it was provided here, which was limited, is a lot like I believe it was the Farrell case. And at the end of the day, and I understand the court's point, and to be fair, I would submit that it's a close call, but that it's a discretionary call. And so the point here is, from the extent of this court's standard of review in terms of this deference to the trial court on this limited issue. But I'm going to turn to the more.
Sure, I understand what you said.
Sure,
It's not a close call under 9609 and 9610.
not referring to, correct.
So you think it's a close call as to whether this can be wedged into bias?
Correct. And I believe that in the scope of that close call, deference can be given or should be given to the trial court. But I'm going to turn now to what I think Your Honor hit on, which I think is, quite frankly, a clear basis for affirming here. And that is the fact that here, this is simply not a harmful error. And when we look at the context of Special versus West Boca, and I recognize the law says that there has to be no reasonable possibility that it contributed to the verdict, but that doesn't mean it's an impossible standard. In Parsons versus Culp, not this court, but still, of course, informative for this court, the second district explained that the Special versus West Boca standard is not to impose a nearly impossible standard. The court should still examine the record in its entirety to determine whether or not there's other evidence to support what the jury came down with. And here, the court should examine the entirety of the record and not just look at.
Can you point us to the specific evidence that would go to support a jury finding of $0 for future pain and suffering?
Well, absolutely. I mean, the evidence here, I think, quite frankly, is overwhelming, and here's why. You've got the fact that Dr. Rausch talked about, and this has nothing to do with the Salazar order, right? So, for example, first of all, it's a matter of credibility. So the jury is evaluating the plaintiff's credibility. And when it came to the issue of future causation, let me start by noting that plaintiff's own treating physician, who was his primary care surgeon, Dr. Melendez, I believe was his name, he testified that he saw no need for future surgery, that he looked at, and as Your Honors saw from the briefing, we presented testimony from multiple doctors, including plaintiff's own physician, and they all looked at the before and after MRIs. And each one of them acknowledged that there were no changes, none. There was no difference. And the evidence was overwhelming that the plaintiff.
Counsel, I'm sorry, I want to make sure I'm understanding your argument there. The witness you just spoke about, who was that, Dr.?
I believe it's Melendez. That's the
Did
plaintiff.
Dr. Melendez testify that Dr. Rausch's surgery was not reasonable and necessary?
No, I don't believe that there was even discussion about that. I don't believe so. But what he did say was that it was his interpretation. And this is in response to Judge Kamoutsis's question. The idea is, what is the evidence to support a jury finding? And the evidence to support a jury finding was the overwhelming evidence from other doctors, including, by the way, Dr. Rausch, who, when confronted with the fact that he had not looked at the before images, that he said he would defer to the other doctors who each did look at the before and after MRIs and testified unequivocally that they saw no changes whatsoever to the cervical spine in the plaintiff. And that was,
In other words, if the jury just rejects the idea that there was a change between before and after, then whatever was necessary after was not related to the fall.
Exactly. And that's a question for the jury. The jury, this is not a case, and this goes back to the colloquy between.
I'm sorry, Counsel, let me follow up on your answer to Judge Mize's question. So are you saying that Dr. Rausch on one hand testified, I needed to do this surgery because of this accident, and then said, no, I really didn't?
No, Your Honor,
Okay.
I wasn't talking about Dr. Rausch.
Okay.
Let me restate what I was saying to make sure I'm being clear. Dr. Rausch saw the plaintiff, did not know about his history, described him as having no cervical symptoms at all, and said that he deduced, based upon his evaluation of the plaintiff, that the plaintiff needed surgery. Acknowledging that he was unaware, he testified that plaintiff was asymptomatic before the fall. Dr. Rausch said that the plaintiff indicated he had instant pain at the time of the fall, which was inconsistent with the record at 1495, when the plaintiff said he did not have neck pain at the time of the fall. Dr.
Did he
Roush,
testify that this surgery was causally related to the accident?
Dr. Roush, yeah,
Yeah.
he did. But that's the point.
The jury rejected that testimony.
That's correct. And why did they reject it? Because 3 other doctors testified that there was no other correlation between the fall and the pain and the neck issue. And they correlated that by looking at the before and after images. So,
So are you saying that as a matter of law, Dr. Roush's testimony would have been insufficient to find that the surgery that he did was causally related? to
not
the
as a matter of law, Your Honor, as a matter of fact. That's a question for the jury. See, the jury.
Based on Dr. Roush's credibility as assessed by the jury?
Well, yes and no, and here's why. Anytime there are multiple doctors testifying and have different perspectives, the question is, credibility absolutely is always going to be a factor in evaluating the issue. But I'm going back to the most significant, I respectfully submit, issue, and that is there no reasonable possibility, or is there a reasonable possibility that the jury reaches this verdict, even if we take the Salazar issue out of the equation? And the answer is absolutely, because if we take this entire issue out, and even if the court presumes that it was improper for the trial court to allow it, we should still look at the multitude of areas where Dr. Roush's credibility was assailed based upon his findings and upon his lack of knowledge about the history of the plaintiff. And that's why I was focusing on that. Dr. Roush testified that he looked at an MRI and said, I have concluded that the plaintiff has suffered this injury from this fall, and therefore I'm going to operate on it. And then when he was confronted with the fact that he had never looked at the prior images, he admitted it. And then he said, and he would defer to those doctors who did, as it pertained to the fact that there was no difference.
Are you saying he really admitted I only evaluated his after condition?
Correct.
Not his before condition?
That is correct. Well, but that's the interesting thing, because in his testimony, he tried to draw a contrast at first between the before and after, because he tried to testify. In fact, he did testify that this fall exacerbated the condition. But then when he was confronted with the fact that, well, in fact, Dr. Roush, isn't it true you never examined the prior images? He said yes. And then when he was confronted with the fact that we had at least, I believe it was 3 different physicians who all did look, including his own, by the way, including plaintiff's own doctor, who all looked at the before and after images and said, I'm comparing these images and I see no difference. When Dr. Roush was confronted with the fact that other doctors had testified that there was no distinction between before and after images, including images taken 2 weeks before the incident, because as Your Honor saw, the plaintiff had a history of cervical issues. He had a prior fall, he had a prior accident, he had prior surgery, he had a history of cervical issues. He was treating for cervical pain as close as 2 weeks before the incident, and Dr. Roush said he was asymptomatic. If that's not a credibility destroyer, quite frankly, with respect, I don't know what else it would be. You have a physician comes in and says that the plaintiff was asymptomatic before this incident. And then he's hearing that 2 weeks before, the plaintiff is complaining about neck pain with a 5 out of 10 pain, where Dr. Roush admitted that that's substantial. The jury had plenty of reasons to reject Dr. Roush's credibility, and that's the reason why they did. By the way, I wanted to make sure I point this out for the court. It was Dr. Melendez-Dedos, to be respectful to the full name, Dr. Melendez-Dedos, Dr. Nagin, and Dr. Colon. Each one testified that the before and after MRIs were, quote, identical, unquote, and showed no changes. That's at the record at 1366, and at the transcripts, pages 303, 688, and 689, 692, 699, 711, and 730. So the record and the testimony presented to the jury was clear on this issue. Dr. Roush admits at the transcript at 408, 412, 428, and again at 430 that he never reviewed the before MRI from his closest couple of weeks before. It was April 2021, so a few months before the accident. Dr. Roush, when confronted with medical records showing pre-incident complaints, he admitted that he would defer to the providers who made those records. That's at the transcript at 433 and 435. And he admitted that the plaintiff's pre-incident neck of 5 to 10 was abnormal. And that's at the transcript at page 435. The point is,
Did Dr. Roush provide then, I understand what you're saying there, counsel. But so then I'm trying to figure out how he tied his testimony to a conclusion of being causally related. Did he say that there was some medical reason not revealed by the lack of changes in the MRI that still made this reasonable and necessary to do the surgery?
I do not think so, Your Honor. I think quite frankly, when he was confronted with these prior findings, he just acknowledged them. And I don't believe that he did in fact say, well, that's because, I don't think he did that, Your Honor. And once again, I believe that would be a question for the jury to evaluate, having heard all of the things that.
But the question for us, and your argument is whether then we can, by evaluating all the evidence, come to the conclusion that there is no reasonable possibility that this improper impeachment affected the verdict.
It goes back to, once again, the discussions that you were having, and I think it was Judge Mize who said, what is the cutoff? At what point do we get to the point? Right? Is it 1 versus 50? Is it 1 versus 10? That's what the totality of the evidence is all about. And I think that's where ultimately deference to the verdict should lie. If this was a case where there was no other issues of Dr. Roush's opinion, and all of those things I just went through didn't exist, we'd be having probably, at a minimum, I'd be acknowledging it's a different conversation. But we're not in that situation. We have a circumstance where there were so many variables that undermine Dr. Roush's opinion that the jury didn't even have to consider this other issue. And I do want to cite some cases because, the concept of harmless error analysis, once again, these are not from this court, so they're certainly not binding, but I would certainly ask the court to look at these if you haven't already. Walters versus Beach Club, the 3rd District, and these are all in our brief, of course. Although the trial court improperly admitted bad character evidence, it was harmless in light of the totality of the evidence. Rodriguez versus State, 3rd District, an isolated comment of an expert in the context of an entire four-day trial was harmless error, and the court should avoid engaging in analysis that looks only to the result. In Bowley Centers versus Vines, the 1st District said, when examining the appellate record as a whole, the improper consideration of medical opinion testimony was harmless under the special standard. At the end of the day, the special standard did not create this insurmountable obstacle where this court should never affirm if there was in fact an error. The question is there a reasonable possibility that the jury would have reached the same result even if you took this out? And I would say absolutely, because I have all this other.
Can you repeat that line you just said?
Sure. When we look at special
I think you said the question is whether there's any reasonable possibility the jury would have reached the same result. I think it's the opposite.
it is the opposite, Your Honor.
Reasonable possibility that the jury would not have reached the same result.
It is, Your Honor. I was just looking at the corollary, and so when I look at the corollary, to be clear, I would submit, the question is there a reasonable possibility, no reasonable possibility this contributed to the outcome? And I would say, absolutely. I mean, in other words, you would get to this outcome even if this issue didn't exist. So therefore, when you look at the totality of the evidence, not just one little isolated incident and use that and quite frankly, Mr. Harris candidly acknowledged we had a very strong case. And when you have a very strong case, then you look at the totality of the evidence and you say, the jury reached this result. And there is a reasonable possibility. There's a strong, I think, quite frankly, an extraordinarily strong possibility that Dr. Roush's credibility was damaged. And more importantly, and not because of the Salazar order, but because of his own lack of information about this issue. And you have the other testimony that reinforced it.
Counsel, you would agree if any number, the $5,000 numbers and then the 0 numbers, if any of those, if we conclude that there's a reasonable possibility that those would have gone up by $1, that meets the special standard?
I don't think so, Your Honor. You know why? Because because that goes
that affects the is there a reasonable possibility it affected the verdict? Verdict will be different if it was different by $1, wouldn't it?
I understand the point.
Didn't say significantly affect the verdict. It said affect the verdict.
So let me answer it differently. I think that to engage in that level of speculation, Your Honor, would require the court to look at this instance in.
Let me give you a more concrete example.
Sure.
again, using as I did for your opposing counsel, $71,000 surgery. So this person, you agree he's the only one who testified as to that's the reasonable cost for the surgery?
Yes,
So this person who testifies to this in front of the jury under oath, and then the jury is told, and essentially gets in a conviction for a false statement, even though it is not a conviction. You would agree, in your experience, counsel, would you agree that jurors generally don't receive people who get impeached with felonies and statements of dishonesty, that those witnesses normally, to the extent you can tell? If the plaintiff, for example, in a auto negligence case, have you ever seen one get impeached with a felony conviction and never seen a plaintiff's verdict on one of those cases?
Your Honor, if the answer, I understand the hypothetical. And I understand that this is a damaging piece of impeachment.
A judge found somebody to have lied.
Understood.
And
And
I would hope that would be a damaging. Doesn't our
understood.
system sort of hang on that?
well, so, and this goes back to, again, Judge Booth's points, and it was a very brief reference, one question and one reference, or maybe one and a half in closing, so to speak, because there was a noted objection.
If you very briefly were informed somebody was convicted of some felony dishonesty, we say, well, it was just a quick conviction.
It's not,
We just said he's a convicted liar.
it's
Doesn't
not,
the nature of the thing matter as much as how much time you spend on it?
Murder, capital sexual
Yeah,
battery,
the-
jury gets word of that,
The more,
what happens
the
then?
more egregious the item, the less time you have to spend on it for it to be, meaningful to the jury. If they just put in, oh yeah, he's a serial killer, right? You probably wouldn't have to mention that more than once, more than for a second for it to really matter.
I understand again the point, all right, and I still believe.
Well, let me skip those.
Sure.
Yeah, so $71,000.
You should probably let him answer.
$71,000. We do know, there is no reasonable doubt that this jury did not accept his testimony on that number. Right? Now, the reason for it, as to whether it's harmless, can we conclude? So I use the $1. Do you think that well, if they would have awarded half of that, would you think that would meet if we can conclude there's a reasonable possibility that but for this improper impeachment, they give them half?
So I do not think that the court can conclude that. In other words, I will accept the
Because of the
premise.
threshold issue
Right.
that you mentioned,
Sure.
that it's really not, there's no reasonable possibility that they would have found that this surgery was reasonable and necessary and causally related by this accident.
That is correct. And I accept the premise of your Honor's question, but I submit that in this case, with the overwhelming facts presented in this case, all of the doctor's testimony, all of the evidence, and all of the other reasons why Dr. Rausch's opinion was not credible, not having nothing to do with Salazar, but having to do with his lack of knowledge about the information and the MRIs. That is the reason why there's no reasonable possibility that this one issue had anything to do with this verdict. So in light of that, I would respectfully ask that this court affirm in entirety, unless there are any further questions. Thank you.
Thank you very much. Briefly, I think the discussion of the harmless error test, it's unintentional by my distinguished colleague on the other side, but the focus is on them and establishing no reasonable possibility that this contributed to the verdict. It's not,
Do you agree with counsel's assessment of the evidence and Dr. Rausch's concession that the before and after, he didn't see any difference and he deferred to the other expert?
Well, so the deferral was, I defer to what's in the medical records, reporting of the symptoms. Just one little bit of clarification. He did testify as a before witness by saying that the condition was degenerative and asymptomatic. Now he's impeached. It properly impeached in the cross-examination, but you didn't have these records. But he was not, but by testifying that this was a degenerative condition and that this caused the need for the surgery with the aggravation. So it's not strictly an after. I just wanted to clarify.
But with that, I guess my point is his assessment of the before was not based on personal knowledge and therefore couldn't be based on his credibility because he admitted, I just read this. Right? So at least for his assessment of what it looked like before, and therefore whether there was any change, right? It's not just that his credibility was impeached. His credibility was removed as an issue because he admitted he had no knowledge. He just said, this is not I just read this.
Right, and he deferred to my time is up, so I don't want to, he deferred to the medical records, but he did not withdraw his opinions on causation in cross-examination. He did not obey.
I'm not saying he withdrew his
Yeah.
opinions. I'm saying he admitted his opinion was based on no personal knowledge whatsoever.
That is true, but he did not review the prior records informing his opinions.
Right, so his
Percent.
as to his, it was based on records and things the other doctors said that the jury had equal access to with him. And his credibility as to the before part just wasn't an issue because everything he was saying he read, the jury could read, right?
That is correct, but the jury, mind you, did award for some of the past meds, and I know that gets to the question of, if there's any possibility that has the defendant established, in essence, there's no reasonable possibility that this devastating issue of impeachment, that affected contributed to the jury's decision to not award for that surgery. I would submit that test is not there. It's not an insurmountable test. I do not want to give that impression, but the test is a demanding test, which respectfully was not met here. I'm way over my time, but if the court has any questions, I would just obviously respectfully ask this court reverse, and if this court does reverse, I would ask that the remand instructions be only on damages and not on the liability issues, that we would not have the burden to have to retry the causation of a single loss, injury, or damage, but that's.
All right,
that's-
thanks.
Thank
Thank
you very
both
much.
counsel, for your arguments. Thank you very much. Give counsel a moment to get set up. All right, our last case for today is 25-0330. Laquadera, apologize if I'm mispronouncing that, the state. Both counsel ready to proceed?
Yes,
All right. Again, our default is 5 minutes for rebuttal. Is that sufficient?
yes, Judge.
All right, please proceed.
Thank you. May it please the court, good morning. Thank you for having oral arguments on this issue. Hanny Demetrius on behalf of the appellant, Carl Laquadera. The issue before the court is, did the lower court err by ordering the forfeiture of over 200 rare animals worth in the excess of $1 million from Everglades Exotic, a 30-year-old properly licensed with 3 full-time employees, by impermissibly applying Florida statute 379.338 and was without jurisdiction to do so. Statute 379.338 does not apply to this case. The title of the statute is confiscation and disposition of illegally taken wildlife, freshwater fish and saltwater fish. Why would the word illegal be in the title if it applies to all FWC confiscations? If you look at all the sections in this chapter, they all deal with the title and the subject matter of illegal. 379.337 deals with illegal taking of saltwater products. 0.338 is what I just mentioned. 0.3381 is photographic evidence of illegally taken wildlife, freshwater.
This seems a little different than what was in your brief.
Judge, I don't believe that we emphasize this point enough in our brief.
Did you put it in your brief at all?
Yes,
Where?
it is under the section, Judge, that says that once the
Give me
warrant,
a page number. Bill, guys, I read your brief really closely. I don't remember this argument. And what you're basically saying is even if he had been convicted and even if a sentence had happened at sentencing, right? Like these animals were just outside the scope of the statute because he didn't possess them illegally.
that's correct,
Right,
Judge.
so where's that in the brief?
Page 14, where we argued that the invalidation of the warrant removed these animals from the scope of this statute. So, and in the rest, it's 0.339, it's seizure of illegal hunting devices.
Sure, the scope, I get your argument about the warrant. I'm not sure the fact that the invalidation of the warrant is the same as saying that these animals just are outside the scope of the statute generally. It just means this specific warrant was not valid. But I don't see anything in that portion of the argument about these specific animals because they weren't illegally possessed as a. Because the allegation here was that he was not that he illegally possessed them, was that he was mistreating them, engaging violations and those kind of thing. It's not that he couldn't possess them, assuming he complied with the statute. But what you're saying here is this statute just wholly does not apply to legally possessed animals.
That's correct.
I don't see that in the brief.
And additionally, it says accordingly, the lower court erred in holding that 379.338 Florida statute applied and authorized the forfeiture of the animals.
But yeah, but you're saying in the brief, you're saying it didn't apply because the warrant was invalid. And now you're saying it didn't apply because these were legally possessed animals. Those seem like two completely different arguments to me.
Judge, I would,
And counsel,
I
I would,
think
I would agree with Judge Mize in terms of my understanding of this argument that you're referring to in your brief is that you were focused on the portion of the statute that requires it to be seized under the authority. And so therefore, since the warrant was invalid, your argument was, well, it wasn't seized under the authority because the trial court quashed the warrant.
what I would say, it falls under this same heading that it doesn't apply. And what I'm arguing today is a more nuance or
Is it a
extension.
completely
of
different
that.
argument as to why it doesn't apply, counsel?
I wouldn't say it's completely different, Judge.
Is there anything? Tell me the sentence about it, the statute in the brief about the statute not applying to legally possessed animals.
Say that again, Judge.
Read me the language of the brief where you make the argument that the statute doesn't apply to legally possessed animals. Because I'm just telling you, I don't think it's in.
I would refer to the same sections that I
But give me the
previously
sentence.
directed.
Literally read it to me because I want to know what
Okay.
you're talking about. 'Cause
There's
you
the
can't
argument.
consider arguments not made in your initial brief, so I don't want to disregard an argument that was made. But I want to make sure we're looking at the same thing here.
It's thus is argued in the lower court, the invalidation of the warrant removed the animals from the scope of the statute because the animals were no longer seized under pursuant to 379 or any other chapter. Accordingly, the lower court erred in holding that 379.338 Florida statute applied and authorized the forfeiture of the animals.
All right, so and your position is that encompass saying that the statute, regardless of the condition of any warrant, just doesn't apply to legally possessed animals. Your position is that that was articulated by the language you just read?
I would say this is a further, more detailed argument on that position.
Okay.
So, Judge, and it's also further articulated by the supplemental cases that the Attorney General provided, where both cases talked about illegal takings, and one of the set of facts was, here you have
Counsel, things in the state's supplemental authorities don't meet your burden to establish error, right? You're appellant. You've got to establish error in your initial brief, right? So if an argument's not in the initial brief, you know, it's often a genuine question as to what level of generality an argument must be made, right? Like, because at one certain level of generality, you could say the trial court was wrong, right? That's obviously not specific enough. On the other hand, you don't want to be so specific that somebody can never meet their burden, right? So there can be a debate as to what level of generality or specificity is required as to an argument. But whatever level of generality or specificity you apply, the argument must be in the initial brief. So the state saying it came up in the state's supplemental authority is just not relevant.
yes, that's not what I'm trying to do. Well, I'm bring up the state's brief to illustrate the distinction between something that is a licensed product, such as these animals, and illegally taken. And I think that is the strongest argument that we have, is that here's a person who's had a license for a certain number of years and is regulated by FWC, and they come in and you have to apply and they come in and inspect, as opposed to someone who just goes and shoots a deer without a license and takes the animal and has no permit, right? And so what becomes the
But
remedy?
Under your scenario, though, even if the warrant hadn't been invalidated. Right, and say he'd been convicted on everything. And at the sentence, the judge pronounced, I'm taking the animals. That would not be valid because these animals are just wholly outside the statute, right?
Yes.
Okay. So if it doesn't depend on the validity of the warrant at all. Right, how could that argument be encompassed in your argument about the validity of the warrant?
I believe when the
Was this
lower
just a
court,
wholly new argument, counsel?
again, I believe it is encompassed under that subject matter, and this is a
So
more.
answer my question. You just admitted, conceded. That this argument does not depend in any way on the validity of the warrant. That if the warrant had been valid, your argument would be exactly the same.
Well, I
But
don't
yet you
think,
said it was encompassed under the argument saying the warrant is invalid. Agree.
well, I don't think that is relevant, Judge, because the warrant here was invalidated. So, and that's not in controversy. And in fact, when it was granted.
I know, but I'm talking about as a matter of presentation, whether your argument was presented to us. And that means it must be fit under some part of your brief. Right, have to have been made in the initial brief. You're the appellant. You've got a burden to show error. Right, you don't get to do that for the first time in a whole argument. And so when I asked you where that argument is, you said it's encompassed under the argument that the warrant was invalid. Right? But you then told me the argument in no way relates to the warrant being valid or invalid. And whether the warrant, even if the warrant was completely valid, your argument would be exactly the same. Doesn't that make it difficult to argue that that argument was encompassed under the argument as to warrant invalidity?
What I would answer, Judge, is this argument encompasses both sides, whether it's invalid or valid. But in this circumstance, it was found invalid and illegal, so it's encompassed.
Does the word illegal appear in your brief? It doesn't appear in that section.
It appears when discussing the statute because the word illegal is in the title of the statute.
What page of your brief is that?
And I think also the argument also falls under when we discuss in statutory interpretation of the statutes to go into the document of the statute itself in interpreting what is the effect of the statute.
All right, let's do one at a time. So you were telling me that there's a page of your brief where you discuss the legal and illegal distinction. Can you just point me to that page?
I did not say that I discussed that legal distinction in the brief.
Well, I said, does the word illegal appear? And then you said it's where we discussed the statute.
It's in the title of the statute, and I'm seeing if we included the title in the statute.
But you're admitting you didn't discuss the legal illegal distinction at all.
I agree that I did not.
Okay, so where was you're just trying to give me a second place that you said the argument was? You said it's
When
also
we make a
this.
discussion of how does the court interpret something that has no case law and it's in the plain reading of the statute.
So you telling us to do a plain reading of the statute just on its own, you think that encompasses the argument as to the statute drawing the distinction between legally, illegally possessed animals? Just giving us the kind of the boilerplate of use the language of the statute, that encompasses an argument as to the statute making a distinction between legally and illegally possessed animals?
The argument of looking at the statute means looking at all the language in the statute is what we argued. And in arguing that this does not apply based on a clear reading of the statute on a plain.
I don't want to disregard an argument that you've made. It's not made in the initial brief. I can't consider it. So I'm trying to make sure, I'm not trying to be overly, emphatic here. I'm trying to understand. The point you're talking about is the portion of the brief where you just give the general rule. Use plain language of the statute. You're telling me that kind of just general statement about how to interpret statutes, that encompasses your argument about there being a distinction in the statute between legally and illegally possessed animals?
Yes, Judge. And also in the goal of fleshing out a complex issue like this is to have the oral arguments in order to flesh out the issue further.
But if just saying that you use the language of a statute encompasses every argument you could make under the statute, like if it encompasses this argument about what the statute actually means, even though it didn't mention that argument, would that mean you could just literally come into oral argument and argue anything about the statute? Because you said, well, we said interpret it based on its language. We can argue anything about its language. That encompasses all possible arguments that could be made about its language.
So we also filed supplemental in this case, and it was Rule 68A-6.003, paragraph 3, subsection A, which gives the appropriate relief in a situation like this, which is a person who had a license and is at some point revoked and removed from the ability to own a license. That person has 90 days for the sale and transfer of those animals. And that is what applies to Mr. Laquadera, who had a license
So also not an initial brief,
in the supplemental.
Seminole authority.
Yes. So he had a license. The seizure happened. During the pendency of the seizure, there was litigation with FWC about the license, and the license is still held to be valid until final disposition of it. And once eventually it was revoked, he should have been given these 90 days to sell or give the animal transferred to ownership to someone else. However, in this case, the court came past any type of jurisdictional deadline. 6 months after he started serving his sentence, he was never noticed that these animals were going to be seized. And now the court found that essentially timing doesn't matter, that the court has jurisdiction whenever to enter someone's sentence and then violate double jeopardy and impose an additional penalty that was never there. So at 6 months after, he loses all his assets valued at over $1 million and over 200 animals. The proper remedy should have been to follow 68A, as I just mentioned. However, in the lower court's order, the court was troubled by Mr. Laquadera no longer possessing a license. Therefore, he interpreted that to be an illegal possession. And he said that 379.338 applies. However, it does not apply because it was never an illegal takeover. There has to be a separate distinction between a person who carries a license and someone who just takes something without any authority or permission. And why would the penalty be the same for those types of situations? And that's why there is codified relief under 68A. In addition, if there was a confiscation or a seizure that was going to take place, there should be a process in everything that's done, right? Timeliness, notice, an evidentiary hearing, findings, none of that was happening. And if there's no further questions, I will reserve my time.
And may it please the court, David Campbell from the Office of the Attorney General, representing the state of Florida. I think I would first like to just ask if this court has any questions, and then I can go into what we argued in our brief.
Yeah, thank you. It seems like your argument to me relies on this not being a sentence, right? Sentencing does have to happen within a certain period of time after the conviction, and you can't do it. You can't re-sentence somebody months later. So like, just draw that out for me. Like, how is this not a sentence? Like, what you're basically saying is that this happened by operation of the law. And so that would mean that that would have to mean it's not a sentence because sentence have to be pronounced.
Yes, actually, that would be based on the brief and statute set 379.338. Yes, this is something that under the wildlife statutes, some of the other statutes that were cited by appellant in his initial brief, those do outline, timeframes and stuff. and procedures that have to be followed
Sentencing
for the
procedures.
forfeiture.
Yeah.
Yes, but in this case, when it's wildlife, based on this statute, it's automatic. They have their due process by the procedure up to when they're being found guilty, or they decide to,
Can you
plead.
say that about any conviction? Like, so say a statute said if someone's convicted, upon conviction, they shall be sentenced to 10 years, right?
But this
And
is,
so-
I'm sorry,
Right, or they shall be remanded for 10 years in prison, whatever, right?
yes.
You wouldn't say that the state could just wait 5 years after and say, put them in jail for 10 years, like the sentencing, there's rules as to sentencing that have to occur, aren't there?
Well, yes, but in this case, as I said, we're distinguishing wildlife. And as it even says in the statute here, it doesn't even have to happen upon conviction. It can happen or sooner, forfeiture of the animals. In this case, wildlife forfeiture can happen sooner. It doesn't even have to happen upon conviction. And our interpretation of that is if there was a hearing or evidence presented to the judge, to the court could find that, yes, these animals need to be forfeited for their own well-being. And I believe that goes with wildlife. Wildlife are sort of under the protection and ownership of the state of Florida, unlike we're domesticated animals. Therefore, the state is ultimately, in charge of their well-being. So that's why in this case, because of
Are you
wildlife,
saying people can't own wildlife?
no, they can, but it's almost sort of like
It's a property,
guardianship or
right?
something for them. It's almost like by the grace, yes, you can have this, you can have this animal, you can take care of it, you can even have a business with it and stuff. But ultimately, if it's a wild alligator or something, by you owning this, you've also gotten a permit for it. And by getting the licenses and permits to possess certain types of animals, you've then agreed that FWC can come in at any time. So it's a little bit different. It's not quite 100% ownership. You get to by grace have these animals. You can take care of them. I said, run a business with
I mean,
them.
it takes a permit to run lots of things, right?
Yes.
Like you need a permit to run a sewage facility. Doesn't mean you don't own the sewage facility.
Our position on this is, once again, is that wildlife is different.
Why
Yes.
is, I'm saying, but you're just saying that, like,
Well,
why would
because
we
the
treat
statute-
wildlife different than every other type of property that people own and that can be seized in a criminal proceeding? And every other type of permanent property, right? I mean, there's many types of property that you have to have a permit to own.
Well, that's true.
And we don't say that the state can seize those without any type of criminal protections.
Well, actually, I don't believe it was without any criminal protections. Well, first of all, as I said, there is the upon conviction or sooner. So that right there, it's, makes it different. Doesn't have to be a conviction. They do have their due process and protections by when the state came in, seized these animals and criminal charges were, filed. They could then, fight these in court, which they did. That's where their due process would be. So he decided to plead upon that point, and the statute is clear. Upon conviction, well, he pled, he knew it, he could have fought this in court, but he decided to take what was apparently a pretty good deal, getting out of the felony charges. And upon that, when he pled, it said,
So how long could the
They're
state have
forfeited.
waited? Could the state have waited 20 years?
I don't,
Because if they're not
And-
bound by the
and-
sentencing timelines, well, like, would there just be no timeline? I mean, could the
the statute actually,
state wait until, say, his kids sue to get them back on his deathbed, so it's 40 years later? It's an elephant, it's still alive, whatever, some animals live that long, with birds that live 100 years.
well,
Can the state just wait till forever?
I can, first of all, the state is not going to, because they do have issues wanting to get these animals placed.
Okay,
But on the statute,
Fine.
yes, getting to your question, this statute, unlike the others, doesn't have a timing requirement in it.
So your issue is they could wait forever.
So yes,
Yeah.
actually, is what our answer would be. I don't think they're
But
never,
counsel,
they're
you
not going
agreed with
to.
Judge Mines a moment ago that this is not a criminal forfeiture, it's a civil forfeiture. Because you
That
agreed
is
with
what our
Judge
position-
Mines that this couldn't be a criminal sanction because the sentencing is done,
Yeah,
right? I mean.
we are under our,
Understood.
that is what we believe this is. This is like any forfeiture with contraband, or like in the case I supplemented
But
with,
forfeitures are civil proceedings.
yes.
Cite me to the rule of criminal procedure that allows, after 60 days after the imposition of sentence, that you can come in to the criminal court and have jurisdiction in that case. Not saying the circuit we're not here to address whether your client can get these animals. It's can they get them in a civil proceeding commenced in the felony case more than 60 days after the imposition of sentence. So you're essentially coming in and commencing a civil proceeding supplementary to a criminal proceeding. I've never seen that. I was in a felony division for 5 years. Never seen it. Ever. I don't see any rule that it allows it to happen. The case you cite,
Yes.
in your supplemental authority points out that distinction, I think, very well. Can find the supplemental authority here.
I think what he's saying is it's gotta be a civil or criminal court. You're taking property. Right? It's like somebody's property, he owns this, you're taking it.
Here we go.
It's gotta be either civil or criminal. You gotta fit under one bucket.
In re forfeiture of the following property. This is the case you just cited in your supplemental authority.
Yes.
Okay. So in that case, Blanchett gets charged with a criminal charge. Is a judge guilty, sentenced to 20 days in jail, given a fine, all criminal sanctioned, lost his hunting privilege for 3 years. Apparently that was part of what the trial court did at the time sentence was imposed. And that's end of criminal case. Then the commission, I think that's also, the parties are different. In a criminal case, there's state on one side of the V, and on the other, there's an individual name. It's in personam. In a forfeiture proceeding, it's in re, what I just said, but then the underlying parties are the commission, not the state of Florida, not the state attorney for a particular circuit. And on the other side, there may be a defendant, but that's because they're entitled to notice in the interim forfeiture proceeding.
Yes.
So after criminal case is over, then your client commences forfeiture proceeding against the vehicle and the road. And lays out the argument, and then the circuit court in the criminal forfeiture proceeding denied relief in part. Court reads the two statutes, one, the criminal punishment statute, and then the one that they opine on is the forfeiture statute, and say under the forfeiture statute, it's mandatory. And so on a direct appeal from the denial of relief, they reverse. They did not say what you seem to be saying is that by operation of law, the criminal court should have ordered forfeiture of these items. They don't say that. And the agency here did not go back to the criminal court. And I want you to answer, wasn't that because the criminal court had no jurisdiction to entertain a forfeiture proceeding? But they go into civil court and they commence the forfeiture proceeding and do agree with your interpretation of this statute that it's mandatory forfeiture. The question here is where, under the circumstances of this case, where the sentence has been imposed, 3800C is clear, gives the court 60 days. It's undisputed that didn't occur here. No motion to correct or modify, even setting aside defense argument that the trial court could have imposed a more onerous condition of probation by forfeiture of this private property. Let's just assume that could have occurred. It didn't, not within 60 days.
Correct.
So what allows to essentially reopen a criminal case and get civil forfeiture relief like the judge did here? You
What-
cite no cases in your brief. You cite no rules. These cases don't stand for that proposition in a criminal court.
That I supplemented with the Ford van case. That was strictly, actually, that was strictly just to show that under a wildlife setting, the forfeiture is mandatory. From what our reading of this is, the state.
That is
WC
meaning
did not
if the
need to-
court doesn't do it upon request by the state, by the commission like here, that it's error and it will be reversed on appeal if the judge doesn't do it because the judge was asked to and denied. The criminal court wasn't asked took by the state. That wasn't part of the negotiated resolution, was it?
Are you talking about in this case here? Or-
Your case here.
In this case,
Mr.
no, it was
Lacudere,
filed-
that was not part of the plea.
Under our feeling is that it happened automatically. And as soon as that happened, since it was wildlife,
It
As soon as
happened
you let it
automatically
in.
how? And so you're saying.
by operation of the statute, by
So be-
operation of 379,
So
338.
counsel, are you saying it automatically became part of the sentence?
We're
Because
saying
I
it's
didn't
not part,
understand your
we're
argument
saying
to
it's
that.
not part of the sentence. We're saying it's,
Counsel, I think
It's-
what he's saying is criminal courts don't just have roving random authority to seize property by operation of law,
correct.
right?
Yes,
Criminal courts have authority over a criminal case,
yes.
right? And it seems like there was a criminal case that happened and concluded. And then 6 months later, you all just file a motion saying, give us these animals. That would just be the criminal court reaching out for something that is not part of the criminal case. By your own admission, you're saying this is something separate. This is operation of law. Well,
We
if it's
don't
something
think this
separate
was
from a criminal
necessary.
case, it doesn't just automatically happen in a criminal case.
We actually don't think the judge needed to file that. At our office, we don't think that the judge actually needed to file this order. We think this order is actually just sort of messed things up a little bit, muddied the waters. We think it was already done. It's just that these FWC wanted to get disposition of these animals settled. So they were like, okay, we've got this other case. Let's at least get an answer from the court saying they've been forfeited.
So what you're saying is the animals change hands and the state can take property through forfeiture with no court order at all. And you guys.
Because the
just thought
statute
it was
says
simply a
shall.
Comfort order.
Because it's, yes, in effect, the statute says shall, so that means it
So-
is mandatory. It was already done.
But in this
Once he pled.
Henry forfeiture case, then why did they even go?
That wasn't wildlife, that was a Bavan. That's the
Correct, but the
difference.
statute said shall.
Right, we're showing, it's under wildlife statutes, it's mandatory. That's all that meant. Shall definitely means shall under wildlife statutes.
Doesn't shall mean shall under all statutes?
Well, if you read that, if you actually read the case there, they go into shall juxtaposed to may. So
Yeah, but
sometimes
shall-
it
I
does.
said shall mean shall, right?
That's what I would say, yes.
But they still needed a proceeding to take the property in that case, right?
In the case of Van, yes.
Yeah, even though it said shall, they needed a proceeding.
Did-
Case said
In the
shall.
case of that, in that case, yes, since it was a van, since it was property. Once again, we go back to, this is what we figured out. It seems to be wildlife is different.
But all right, but you
seems to
said it's
be it.
different because it uses the word shall, but the other statute uses the word shall too, so it's not different in that sense.
No, it's different because of the nature of what's being forfeited. Treating animals differently than treating
Well, that's
a
not based on
van.
the language of the statute, that's just you saying that.
No, well, it's actually this based. Shall being, it's done
But
either
both
upon conviction or
statutes use
before.
Shall, counsel, that's
Mhm.
not unique to wildlife. There are other forfeiture statutes that say shall,
That's true.
so to say wildlife is different because of the use.
Not
of the
needing the
shall-
hearing, though.
Don't interrupt me, counsel. To say wildlife is different because of the use of the word shall doesn't make any sense when other statutes use shall. What am I missing?
And I'm not explaining it correctly. That's
Okay.
not what I really meant. What I'm trying to say
Counsel,
is,
let me ask you this, and maybe this, if it's tied to Judge Meyer's question. So, plenty of statutes on the books about drugs, being
Yes.
illegal possession of drugs. There's a provision in that statute that says if you're upon conviction, your driver's license shall be suspended or revoked. Shall.
yes,
It's mandatory. But sometimes maybe I missed something. I'm the trial judge and I fail to pronounce you lose your driver's license. Does it automatically happen anyway?
I would think so by the statute, yes.
Well, meaning if you're saying, can the Department of Motor Vehicles institute an action over here outside of felony court or the criminal court to suspend the license? I would agree with you, but I'm aware of no authority that would allow you, I've never seen a case where it would allow you to go back into criminal court more than 60 days later and say, Judge, you forgot to suspend the license. It says shall, you need to do it now.
Okay,
You have a case that says,
no. No, I don't.
Mandatory fines for trafficking offenses. Sometimes judgments it. More than 60 days later, can the state come in and say, Judge, sorry, got to impose this $50,000 fine for the minimum of the trafficking? Can they do it?
No, that would be that would be changing the criminal sentence.
Correct.
Whereas with the license, that would be, also an administrative function at the same time.
Because there's another place to go, either an administrative agency and maybe upon proper procedure to a circuit court in a civil case, right?
Yes,
Any authority that allows it to be done, yeah, in this case, the case jurisdiction of this criminal case.
I don't have anything other than that.
Let me use
Unless
the
you wanna say the court
restitution
changed
example.
jurisdiction.
Restitution example, the statute mandates restitution if there's a victim of a violent crime.
Yes,
Judge forgets. Can you come back more than 60 days later and get restitution?
no,
Let's say the judge orders restitution. Can you then come in later and say, we want to sue the defendant civilly so we can get some pain and suffering that isn't provided for in the restitution statute? Can you do that in the criminal court?
no.
That's what I'm struggling with, counsel. Question for us is not whether can your client get relief anyway. I think get relief where it did. And that's, I just, none of the authorities, but if there's something that I'm missing, please, what's your best case that help in
Other than-
this circumstance like this?
I don't have any other cases to, our argument was based on, what the statute said, that by operation of the statute, it was done as soon as he pled and was convicted.
I mean, we don't even know, we wouldn't be privy to it, certainly not in the record. That may have been part of the negotiation process of this plea, could it not?
No, in the plea, he says there's nothing else that they're reserving.
What I mean is like, hey, if this is what these are the negotiations, it's like, okay, my client will keep this, he'll plead to these misdemeanors, you're gonna drop the felony and the M1, and this is the deal. That could have been
Well-
negotiated, right? And we don't know.
Well, no, I mean, it's not in there, but,
Right, we know it's just not addressed at all.
that's true.
It
It's
doesn't
not.
come up in the colloquy. I read the colloquy, it's not mentioned at all.
I agree, it's not. And I think it should have been. But the defendant, if he was disagreeing with what had happened, he missed his chance to appeal, and he
His
also
point
did
was
try
there
to-
wasn't anything to disagree with because it wasn't there. They didn't say in here, we're taking your animals. So there was nothing for him to disagree with. It's not like they said, we're taking your animals, and he had a chance to say, no, that's not what I agreed to. The plea did not encompass taking the animals. He had no reason to object to a condition that wasn't part of the plea.
It wasn't even
Uh,
part of the factual basis. You stipulated the factual basis in the venue.
Well, that is true. But what I would say is, once again, our argument has to fall back on this statute, which is where we go to. It says shall as soon as he was convicted. And he knew what the statutes were, and he should have.
Could they do that in other instances? Like, could they say, you can take property or fines as a criminal conviction? Could they say, if you're convicted of this statute, you lose your house? And they don't have to, upon conviction, you lose whatever house you own, right? You can take properties as a criminal penalty, right? But because they said shall and upon conviction, the state doesn't have to include it in the plea or the sentence. And they don't have to sue you for it. They don't have to bring civil forfeiture. Just if you're convicted, they could not mention it in the criminal case and just send guys with guns in and take your house. With no court order, never having been mentioned in your sentence, and no civil forfeiture. Would that be constitutional?
Oh, that's sort of an extreme example
It's,
here,
it's
but-
literally the exact same example. It's not extreme at all. It's the exact facts of this case. It's just a house instead of wildlife. It's the opposite of extreme. It's like directly on point of what we have here. You have a criminal conviction
Mhm.
where property was not mentioned in any way whatsoever. And there was no civil suit to take the property. And your position is that at the moment of conviction, the state could just seize it with no court order at all. other than the fact that one is a house or one is wildlife and you could plug in any type of property, the facts are identical. It's not an extreme hypothetical. It's the exact facts of our case with a different piece of property.
Unfortunately,
Would that
going
be
by the,
okay?
I'd say going by the statute, since the statute does say that upon conviction, then he had better be very careful before he agrees to a plea.
So all of, say just all your property, say, hey, if you murder someone, it could be a serious crime, so it's worth it. Upon conviction for murder, all property you own is forfeited. So guy pleads to murder, state doesn't mention it, property is not mentioned in the plea, it's not part of the sentence. There's no civil forfeiture action. State can just start going around the state, sending out armed law enforcement officers, take everything you own, no court order. This sounds proper to you. This sounds like a thing the state's allowed to do.
I would not say that sounds proper, no.
But all you're telling me is, well, with this statute, they can.
Mhm.
And the only thing you're telling me is that it's based on this word shall and upon a conviction. But you're telling me if that shall and upon a conviction language was used with any other property, that would be something the state clearly couldn't do, and it would seem really absurd.
If it's put in there, unfortunately, the state might actually start being able to do it if it's in the statute and you start agreeing to it. So
Well, that's my point. He didn't agree to it. It's not in the plea. So I'm saying,
if it's in the statute that he knows he's being charged with or is aware of and agrees to it.
yeah. So your
yes.
position is that's okay. So if someone pleads to a crime, statute says if you're convicted of this crime upon conviction, you shall forfeit everything you own. So same statute, just different property. Your position is, yes, with no court order, nothing in the plea, no criminal sentence, no civil case, state can just go around seizing everything the person owns. That's totally appropriate under the Constitution.
What I think is that this statute, which hasn't been litigated a whole lot, that is what it says. Whether or not the legislature needs to go and rework it, they might. That is what it says.
Okay,
In this case,
going to the you keep referring to the statute in the face of Judge Mai's question about the constitutionality. So let's set aside the constitutionality. Under the statute, it says if the animal, just use the short form, seized under the authority of this chapter.
yes.
I read the colloquy, I looked at the plea agreement. I don't even see a finding by the trial judge that these were in fact seized under the authority of this chapter, any other chapter, or rules of the commission. Didn't see it in the plea colloquy, didn't see it in the plea agreement. In the motion to suppress, the court quashed the warrant, so the warrant's out, can't be under the authority of the warrant. State stipulated to quashing the warrant.
Yes.
And then the court reserved on the issue of what would be suppressed and what was properly the commission made the alternative argument. We have an alternative argument, Judge, as to our authority. I don't see any findings by the trial court on that. You agree with that?
The trial court apparently accepted that because they didn't quash the animals they didn't say the seizure of the animals was incorrect. They didn't quash that.
But they didn't make it, the trial court didn't make a finding that they were seized under the authority of this chapter, did they?
Not that I know of, other than they didn't suppress the seizure of the animals. So the condition of the animals was admissible. There is a footnote
Correct. Yeah, the court did not suppress the evidence in terms of admissibility at the proceeding.
But I think that goes to the finding that they did have the alternative way to seize the animals. They had authority. He had gotten the licenses to possess those animals. And you agree when you get those licenses that your facility is subject to, inspection at any time.
So that
So
could
they
have
could go
allowed, had it been negotiated, that could have allowed perhaps your argument as the court could have imposed that as part of the probation. That would be your argument. Trial court could have done it, but didn't.
Yes, I think so. No other questions?
All right. Thank you,
All right.
counsel.
Well, then we would ask you that you affirm. Thank you.
So under the state's argument, a person is entitled to no process, no findings by a court, no notice, and a court has unlimited jurisdiction. The only time something happens automatic in a criminal case, as Judge White mentioned, is when it's noticed to the defendant during the plea colloquy, right? Because pleas have to be knowingly and intelligently done and voluntarily done.
Well, counsel, isn't that an overstatement? I was using specific examples. There are in fact, like for example, sex offender probation specifically says by statute does not have to be orally pronounced. It's automatically imposed, right?
Well, you have to notify the person that they are going to be a sex offender and the designation. And then when you go and report to probation, they enumerate all of that.
And the statute specifically says the court doesn't have to pronounce all of this litany of conditions.
No, it just has to inform you that this is your designation, and then your attorney has to explain to you this impact.
Do we have that here? Do we have do you have any portion of these statutes that say without pronouncement by the court, the animals are forfeited?
Say that again, Judge.
Is there any provision of the statute that you're aware of that says the forfeiture of the animals upon convictions, it mentions upon conviction shall be forfeited? Certainly doesn't say there, even if it's not pronounced by the criminal court. But is there another place? Is there any other place in the statute that you're aware where it says, oh, this forfeiture word that's referred to over here, that happens automatically without pronouncement by?
No, and in fact, if you look at the preceding statute, 379.337 lays out the process procedurally for seizure and gives notice, procedure, all the requisite things that need to be done. I believe that it inures to the following statute that a process is necessary because nothing is automatic, right? Everything you are afforded due process. And in fact, this statute is a little vague, right? Because it says upon conviction. Conviction of what?
Counsel, can you address that or sooner language?
Yes.
What would be the process for implementing that upon conviction or the or sooner language?
Right, and that would be my argument that the preceding statute applies, where if you go through the forfeiture process, that can happen prior to conviction because
So you're saying
it's
it need to be a
separate.
civil forfeiture proceeding?
Yes. And so, and then it says upon conviction or sooner. It doesn't say after, right? They put time specifications in it, although not specifically, it doesn't say after, but it tells you at the time, which is upon, and sooner. It doesn't say after, right?
Well, would it allow a criminal court as part of a negotiated plea and probation if the court withholds adjudication and nevertheless order forfeiture of the animals? That would be prior to conviction, right?
I would think that you can agree to that, but it would have to be implemented in a civil court.
Why?
Because
Where,
I
where,
don't
where
think-
does it say civil court? It says a court order if the court so ordered.
because I think that forfeiture is a civil procedure.
But it could be criminal as well, could it not? Are you
Well-
saying this statute prohibits the imposition by a criminal? I understand your argument about we're outside the 60 days. But let's say, are you saying that it would be an illegal sentence if your client would have added a negotiated term, I agree to forfeit all these animals? It's part of my plea.
You can negotiate anything, however, it's.
Not
in-
anything.
No, you can't. Because then you can't-
All right,
You can't
most
negotiate illegal
anything,
sentences.
most anything.
But not really though, like you can negotiate a legal sentence, you can't negotiate an illegal sentence. So his question is would that be a legal sentence or an illegal sentence?
I think you can negotiate it, however, its enforcement is in a civil court. Because that's where forfeiture happens, right? You can
You don't think
agree
there's
to
any such
it.
thing as criminal forfeiture?
Well, for example, but what I'll back up and say, it's a different proceeding altogether, right? So for example, if you are arrested for narcotics and you have money as well, as part of the criminal case, they don't seize the money as well. You have to go through a different forfeiture where you're put on notice that they're taking that, and all that happens in a civil court. They put you on notice, there has to be evidentiary hearing, there has to be findings by the court, and then the court makes a ruling, we're gonna forfeit this or not. So, and I think that's what clearly didn't happen here. There was no
Oh, we
process.
know it didn't happen here, but.
No notice, and it was completely outside the jurisdiction, nor did this even apply to this type of case, this statute as a whole. Thank
Right.
you. We would ask that you grant relief for Mr. Lacudere.
All right, again, thanks, counsel, for your arguments. And that's our last case for the day. We will be in recess and adjourned for the day.